circumstances I am mentioning this matter. Yesterday, this matter appeared as item number 12, relating to releasing of money in respect of Mahatma Gandhi Rural Employment Act scheme. This matter is being heard by the division bench for the last 4 years. Ultimately, the division bench directed the entire manipulation, misappropriation of central government funds are there. Inquiry will continue in respect not only in 4 districts, all districts in West Bengal, and a committee was constituted and a nodal officer was also appointed. Now, there was no direction to pay any arrear in respect of the claims. And there was direction that the central government will usurp the entire power from the state government, take action against the delinquent or corrupt people who usurp the money. Now, there was no interim order for payment of arrears. This is being heard by the division bench. It was brought to the notice of the present Honorable Acting Chief Justice. Their lawsuit did not pass any interim order. Earlier, Justice Somen Sen was presiding over, no interim order was passed. All matters which were attempted to be moved before the learned single judge, bypassing the division bench, have been referred to the Honorable Chief Justice Court. Even thereafter, this matter has been moved by Vikas Bhattacharya, who is appearing in all these matters, for either for Khet Mojuri Association or all that. So where is the scope for entertaining an application by the single bench?
But Mr. Chakravarti, the problem is that the advocates who are appearing on behalf of the Union of India,
yes, they could not apprise your lordship.
No, they are not bringing anything on record. They are only putting 2-3 papers. Central government has done this. Central government has done. They have not mentioned anything about
that is why it prompted me to mention and come before your lordship. Let it appear as to be mentioned on the reopening date. We shall produce all documents and it should be dismissed to the exemplary cost.
But I also request you, who is appearing for any of, not only with the Union of India or state government, because I also find in the state government also many of the advocates, subsequently some advocates are now, my lord, this is a thing. So they are not been properly guided. When the court has passed an order, then mentioning the matter, either the advocates who are appearing for the government, they should bring all the facts before the court.
Yes.
They are not. Yesterday, I have heard not about half an hour the matter was heard.
Yes.
Half an hour. Only, yes, he has produced only 3 documents. He has produced 3 documents, 2022 order, March 2025 letter, and 1 letter. So I find, yes, he's giving 1 by 1 letter. So I
appreciate. This is a fault on our part. The learned junior appeared. But the learned advocate who appeared in all those matters, he also appeared in this matter.
Have you issued the notice?
No, I've actually let it appear on the reopening date.
Have you issued the notice? Mentioning notice have issued?
No, we could not. Yes.
So let it be fixed on. I'm not there. Okay.
Yes.
In this ले ना हो, इसको जो है 2 तारीख को to be mention में रखी है.
On the reopening date.
My lord, yes. My lord.
And in the meantime, we shall
let senior voice, yes.
But yesterday, your lordship had given me leave to move the vacation bench in a matter. It's gone on as leave to mention before the vacation bench. Then the file will not go. So it has to be directed, just leave to move instead of leave.
Keywords. Leave is granted to the producer. Yes, what do you want?
Well, I just want leave to move because otherwise the file will not.
The matter is mentioned by the learned advocate. फाइल अच्छे की इसका आज नहीं है इसमें नहीं वो हम मेंस वैकेशन बेंच बोल रहे हैं ना मूव बिफोर मैं मेंशन बोलेगा फिर चला जाएगा एक काम करो इसको सप्लीमेंट्री लिस्ट कर दो 2 बजे हम देख लेते हैं सप्लीमेंट्री लिस्ट में लेके आ जाओ हम रख देंगे यस
with your lordship's kind leave but the order which was passed by your lordship yesterday but at 9:55 p.m. last night there has been an order of rejection passed by the SDO enclosing the report, my lord, by the OC of the concerned police station. It's perimeterally a reproduction of whatever the OC has stated, my lord. And it is beyond the jurisdiction. The my lord, honorable leader of the opposition, it was written in the application that he will be visiting Gangashagar today and visiting Kopil Muni Ashram to take, my lord, for religious purposes. From Kopil Muni Ashram, he will be traveling 14 kilometers to the venue of the meeting. So they have tried to make out a case as if the leader of the opposition will be traveling from the side of Calcutta to the venue along with 10,000 supporters, my lord. So a lot of things have been stated, my lord. But the meeting is scheduled from 12 to 6, my lord. But I was seeking for my lord's kind leave, my lord, if my lord permits me to move this matter, my lord. Otherwise, every arrangement has been done there, my lord. And nothing, in fact, has been stated about the loudspeakers. It is only about whatever the OC has told him. He has annexed that report. So it's pari materia, my lord. It's a case of,
What is your grievance now?
my lord, they have come up with, they have passed an order stating that Gangashagar Mela, my lord, the Makar Sankranti is on the 14th of January. They are saying that no, preparations are underway for the Gangashagar Mela. Therefore, there can be pilgrims who will be visiting. Now, my lord, Gangashagar Mela, on an average, there is a footfall of 4 to 5 lakhs. So they are saying a few thousand can visit, and that road is used for VVIPs and VIPs. So that might lead to obstruction if the leader of the opposition goes. So, my lord, Gangashagar during the festivities, well, the Honorable Chief Minister, all the cabinet ministers, they are all visiting there regularly during the Mela. Now, we are 21 days away, my lord, from Makar Sankranti, and they are citing it as a ground, my lord. Apart from that, my lord, they are saying they even failed to appreciate what was written in the application, that from the ashram, he will be traveling to the meeting venue, which is around 15 kilometers by road. They are trying to make out a case that no, as if he will be taking the ferry. If he takes the ferry, then people may face inconvenience, but somehow or the other. And despite my lord categorically recording that, my lord, unreasonable grounds cannot, my lord, be cited for deterring the fundamental rights of, my lord, having a rally or a meeting, my lord. My lord, I was seeking for, my lord's kind leave, my lord, to move this matter, my lord. I will be pressing for interim order today, my lord.
So
It's-
how, which time it can be taken?
My
You
lord,
have
it's
not
from
informed
12.
this.
It's from 12 to 6, my lord. If my lord permits us, my lord, no, we will be ready to, my lord, defer it also, my lord, by 1-2 hours. He is waiting there, he will wait there, my lord. Because all arrangements are made, my lord. The stage has been erected, but they have stated, my lord, but the area measures above 1 lakh square feet, my lord. It's 2.3 acres. So it's above 1 lakh square feet.
Yes.
They have said that the area is inadequate for having 10,000 people. 1 lakh square feet. Then they say no parking arrangement. Out of 1 lakh square feet, 60,000 is being used, my lord, for the meeting purposes. Remaining 40,000 is for parking.
Okay, yeah. I'll allow to affirm and list the matter at 12.
Lord, may I have your lordship's leave, my lord, to
Supplementary list.
My lord, my lord,
Lord, may I have your lordship's
my lord,
leave?
the matter I have already mentioned earlier in 3 occasions on 12th, 17th, and 22. It was lastly on yesterday. It was prayed before you to issue a supplementary request is taken up. The matter is a very urgent matter because of the I have been cancelled the 4 tenders of 1 crore each year that is involving 2 crores. I have been unlawfully rejected in violation, gross violation of the government procurement policy GFR 2017.
What is your grievance? I am not
Grievance-
here to hear the
My,
lecture.
my grievance is immediate. They are going to award the final contract, rejecting my technical bid. Immediate interim stay is required. So matter yesterday you have told that today is the matter will be taken up
It
at
is
any
in the
point of time, and that is in the list in 91 under urgent motion. But if it is not taken up today,
You mention it.
Lord,
If it is not taken up, you mention it.
may I ask your lordship indulge us, my lord?
my lord,
Lord,
this
this
is to be
matter-
heard, otherwise,
That's I'm telling. If it's not taken, you mention it. I will take your matter.
okay. May
It
I?
is in the list. I cannot go 191 to 1.
But,
Court is telling is in 91. I will take the matter if it is not taken at up till 4:30. I will take your matter. But make sure the other party will be up here. Otherwise, I will not hear. Yes.
I have
Lord,
served
this matter is relates to my EWS certificate, my lord. 5th is the date, my lord, when I have to produce the certificate. Otherwise, my candidature will be cancelled, my lord. Lord, considering the urgency, your lordship has granted me leave to move it yesterday.
This EW certificate is allowed to your application is allowed. I think the 100 application is there.
My lord, I said it.
100 advocates will
My
come
lord,
the same.
my lord, the cut-off date they had fixed, but within that cut-off date, I had certificate.
Because
based on-
every advocate is coming, there's EWS certificate, the authority has rejected,
Well,
not your single application.
well,
If your one single application is allowed, the other will be a.
well, on that day, on the day I had applied for, but I had my EWS certificate.
It is in the list.
It is in the list, but 5th is the date, format.
In which number your number is?
Well, 98 and 108.
Okay, let us see how far the court will go, then you.
If it is not, may I mention before recess?
Yes.
Lordship, under compelling circumstances,
After this, at 2 you mention if it is not taken.
under compelling circumstances, mention on matter, Lordship, the matter, item 104 in today's list, the Lordship, matter related to the one illegal detention. Matter is related to Lordship illegal detention, Lordship. The petitioner before your Lordship served the sentence, Lordship, 2 years. In spite of that, his extra custody in the for more than 40 days, Lordship. Your leave.
1 week, nothing.
So these are leave matter, Lordship. Your Lordship granted the leave, Lordship.
Correct, I have granted leave, come.
Any time, Lordship.
1 week.
My lord, may I?
How many days you are in illegal detention?
Near about, Lordship, more than 40 days.
So what will be happen within 7 days? You have spent 40 days illegal detention. What will happen in the 7 days? Court will be reopening. Court is not going anywhere.
My lord, may I have your lordship's kind leave to mention
Lordship.
item number 151 of your lordship says this. It is that matter, my lord, when the roster was challenged by my lord, aspirants, my lord, of the physically handicapped categories, and my lord, the learned advocate general was to appraise before your lordships with regard to the steps taken by them. My lord, your lordship was kind enough to fix this matter as 2 p.m. in other days, my lord. Today, although it is not appearing marked as 2 p.m., but I was requesting your lordships, my lord, praying that let a time be
It's
fixed.
taken tomorrow, but the AG was not there. What can
Yes,
be
my
done?
lord, we will be suffering, my lord, since
What can be done if
31st
the other side is not here without
my lord,
hearing the other
may I
side, the court
may I
possible.
take your lordship's leave? May I take your lordship's leave to inform the office of the advocate general?
Come on 5, issue the notice.
My lord's kind leave, my lord,
It is not taken today.
my lord's kind leave, my lord, to mention this matter. My lord, pursuant to an order of the Supreme Court, my lord, with regards to the new Waqf Act, my lord, the Mutwalis are supposed to approach the tribunal if they are not being able to register their property under the Umeed portal. Now, my lord, for the last 1.5 years, I am the Mutwali incumbent. My lord, I have not been declared as a Mutwali. My lord, my legal remedies are being curtailed. May I move this application on 29th?
20?
29th in the vacation bench, my lord.
No, who has restricted?
Leave, my lord. I'm seeking leave to file this application.
It is not leave, is not required. You go and go and take.
My lord, the roster,
Unless
my lord,
and
the
until my
roster.
lord grants leave, my lord, it will not be listed on the 29th.
Yesterday I have granted 100 leaves. The vacation bench will be again overburdened. What will be happen 29th if it is moved or the court is opening on 2nd?
No, the only difficulty is, my
What
lord,
will happen within
already.
2 days? You tell me your Mutawalli will go to the foreign.
No, my lord,
And-
my lord, the only difficulty is that I am already late.
Correct, I am telling. If you affirm the
Then my lord kindly keeps it on 2nd of January.
date, mention the date returnable on 5th. File it.
My lord, without 24 hours,
Leave is
the-
granted to the file. Leave is granted to file before the vacation bench.
Your lordship, may I
my
be
lord kindly
permitted to
mentions the date.
mention,
Otherwise, it will not appear on 29th.
On 29th
Great.
December.
your lordship, may I be permitted to mention, your lordship?
Debate to the judges. Can you give the name of the judges? Because you are giving the suggestion, the date and the court, and you give the name of the judges, advocate who can be elevated as the judge. So I can refer the matter to the ministry. Very unfortunate.
My lord,
I don't know where from you got all the ethics and which chamber you belongs.
My lord, may I be having a lordship? My lord, yesterday, my lord, item number 636 was mentioned. Leave was sought to move the vacation bench. Your lordship had been kind enough to grant leave to move the vacation bench. But the difficulty is, my lord, unless and until there's an order to move the vacation bench, this matter will not be listed before the vacation bench. I'm only seeking that much, my lord.
Which matter?
Item number 636, my lord, of today's list, my lord.
Item number 636. Item number 636, leave is granted to the petitioner.
On 29th, my lord.
As per the prayer made by the counsel for the petitioner, leave is granted to the petitioner to move before the vacation bench.
On 29th, my lord, if your lordship.
29th of
Grateful, my lord, grateful.
2020.
Your lordship, may I be permitted to mention serial
Grateful,
number 97, your lordship, under extreme urgency. There is complete anarchy and they are during the pendency of the writ application, the treasurer has been removed and the president has also been removed. Now they are very much willing to install a industrial water.
Come on 5th, madam. Come on 5th.
Your
Today it
lordship,
is not fixed.
any time may be fixed on 2nd, your lordship. Today it
Second-
may be overburdened.
Come on 2nd, I will see, then I will fix the date. Come on 2nd, come on 2nd.
Your
move the-
lordship, I have been mentioning for quite a long time, your lordship, unless a stay is granted, the entire central.
Whether your matter is listed, whether a matter is listed.
Yes, your lordship,
Item
unless
number,
97. It may be taken up today itself. If
record an item number 97. Item numbers 97. In counsel for the petition prays for urgent hearing, but this court is not having sufficient time to hear the matter today. Let the matter appear on 5th of January under the heading adjourn motion within the 10 matters.
deeply obliged, your lordship, deeply obliged.
Within 10 matters.
Deeply obliged, your lordship.
Urgent motion. Urgent, huh? Yes.
I am praying for leave, my lord. Item number 638 to move the vacation bench, my lord.
638 record. As per the submission made by the counsel for the petitioner, leave is granted to the petitioner to move before the vacation bench.
My lord, I'm paying for leave to move item number 612 before the vacation bench, my lord.
One thing I am doing. All the matter which has not been taken up by this court today, the matter we mentioned before the vacation bench. That will be better. To
612.
so this order again I have to sign the all orders till 9 o'clock.
My lord, the petition is an octogenarian citizen.
Serial number so and so mention the liberty given to the advocates who will mention before.
My lord, kindly consider the petition is an octogenarian citizen.
Don't know what will happen within 2 days. 29 and 2. What is the different distance? 2 days. What will happen? Bench hunting.
My apologies.
I know why you are mentioning all these things. No further mentioning, yes.
My lord, only one thing, my lord, item 102, my lord. My lord, may I have your lordship's leave, my lord, to come back and mention at 2 o'clock, my lord, with the other side, with a notice to the other side, my lord, in case, my lord, it is not taken up, my lord. 2 or 4:30, my lord, against the ECI, my lord, had granted leave. There was another matter, my lord, 7:47. I will trouble your lordship after the vacations and not take the risk, my lord, now.
This is a new motion, my
Call the letter.
my lord. This is
Call the letter. Call the
Your
letter.
Lordship,
this is a new motion, my lord.
Your Lordship, I'm seeking correction of the order, Your Lordship.
Come on second. It will be listed. It will be, if it is not listed in the monthly list, let you mention.
My lord.
Wait the monthly list first.
My lord, inclusion in the list, my lordship. The names, my inclusion.
You are not given the name.
Lordship, before the rising of the court, the passport matter regarding Mr. Bihani had appeared, Mr. Kumar Jyoti Tiwari, Mr. Ashok Chakraborty, ASG had appeared.
Yes.
Your Lordship, the names have, and the state names have come in instead of Union of India.
My lord, sir.
Milord, the item number 1, Milord, I am appearing on behalf of the Union of
right.
India. My lord, I am led by learned Additional Solicitor General of India as well
Judge
as
Sahib Dakchin, Judge Sahib Dakchin.
Miss Pandey is there.
Are
By the London advocate of the Union of India and submit that the matter was taken up tomorrow. And this court has passed an order, but in the order, instead of name of the London advocates appearing for the Union of India, it is the name of the state has been recorded. In the order dated 23/12/2025, the state was not appearing.
Your Lordship, state is not a party there.
Instead of the name of the advocate was appearing for the state, name of the Union of India may be recorded.
আমাদের নামগুলো দিয়েছে
Recorded, which are as
নাম দেয়নি নাম দেয়নি
Correction করিয়ে দিচ্ছি।
Lord, may I seek one indulgence, my lord? A matter has been released by a coordinate bench just now, holding that doesn't have determination. Determination pertains to this bench. Some urgency, but today, my lord, Your Lordship kindly keeps it after the vacation on any day. Urgencies, it has to be heard before the 7th. Any day before the 7th, Your Lordship keeps it.
Which matter?
My lord, this is a new rate, but it was
It is
released.
not in the list.
It is not in the list. It was released just now by the coordinate bench. My lord, we were hoping to move it as an unlist, in a supplementary list. If it, Your Lordship,
Court is having determination.
yes, this court, that court has held, this court has determination and has signed the order also. It's just being up.
My lord,
Come with
kindly
a supplementary or Your Lordship keeps it on any day.
My
So
lord,
na,
my lord,
list the matter on
আমি order-এ pencil-এ লিখে দিয়ে দিয়েছি।
6th of January,
Well, it's 6th is the 6th other than any day other than 6th, please.
then 7.
7th I'm not in. The 7th is the date, my lord, of everything. 2nd, 3rd, 4th,
5th January, 5th January, within 10 minutes.
Great. Great.
My lord,
Yes.
my lord, kindly hear me for a moment. Yesterday,
Wait
I
for the
mentioned the
leave
matter of arbitrary disconnection of the electricity, and your lordship was kind enough to fix the to direct the court officer to fix the matter today. However, it is still appearing as item number 79 under urgent motion.
Okay, you
My lord,
wait with the court because you persons are mentioning like this. I don't think the list will be called.
my lord, kindly fix
Yes,
the
call
matter
them,
today.
call
Your
them.
lordship, 106. I was praying on 2nd if it could be taken up within.
Automatically, if it is not taken, it will come on.
My lord, kindly fix the matter today at 12.
Let me wait for the till the lunch. If it is not come on at 2:30 or 2 p.m. Yes.
My lord, I'm for the petitioner, my lord. My lord, I've obtained the intended addresses, my lord. There's a prisoner's petition attached to this.
Have you served a copy to others?
My lord, I've served a copy to the union, my lord, and state as well, my lord.
Kolsur Pier Tenganga.
পৃথিবীর সব থেকে বড় বড় লোকগুলো সব বেটে চার্লি চ্যাপলিন, বার্নার্ড শ, আর কত নাম নিবি?
So, yes, you got the
I have gone through, but they
Address has been given.
Prisoner's petition.
village Kolsur.
your address has been
Where is the
disclosed.
address? Which
This
number?
is not 24 Parganas, my lord.
Village Kolsur, which premises?
They
How
don't
how the officer will you are in customer correctional of how the station of the officer in charge will identify the
My-
place.
My lord, the PS is there, Ganga.
Yes, is the see it is the village. Which premises you will reside?
My lord, the difficulty with villages is that they do not have premises. I can give the name of the person.
Yes,
under
in whose house?
Yes, my lord,
House
I can
number,
give that
land,
name,
khata, the dag number.
My lord, I can
flat
provide that
number.
name. Care of I can provide, my lord, because this has come from the prison itself, so I could not edit
Lord,
anything.
I have objection to this. Degonga is a border area.
Correct, that's what I'm telling.
Well, I'll give you the give the person concerns under whom
Okay,
care of.
I am not passing any order. Only I will direct the state, the officer in charge, to verify the address given by the petitioner, whether it is feasible to allow the petitioner to decide.
No, that apart, Lordship is aware. In view of the new act coming into force, amalgamating all laws, entry into India, Passport into India Act, Passport Act, and the Foreigners Act. Now, Section 12 of the new act, which has come into force on September.
The last petition I have given my book, your lordship.
Correct.
File as
Section 12, blood of this. I have said that these books are submitted, never returned.
It was given, I think. कहाँ रखे? बुक कहाँ रख देते आप? बुक देते कहाँ रखते हैं? Section 12
of the Immigration and Foreigners Order 2025. Order connect এটা পরে connected order আছে
Yes.
amalgamated. Power to prevent, defect, impose restriction on movement and deportation of illegal migrants. May I read it?
Section 12.
Section 12
Yes.
of this order.
Yes.
1. The immigration officer
Yes.
at the immigration post shall take steps, including examination of foreigners and inspection of career, to prevent foreigners attempting to enter into India without valid travel document. It is not applicable
It is
now.
not applicable.
Now, kindly come next. The designated border guarding forces or the Coast Guard shall take steps to prevent illegal migrants attempting to enter India. That is also
That is
not
also
applicable.
not here.
Kindly come to 3. The civil authority, that which has fallen from my
Correct.
time and again.
Correct.
Civil authority, the state government or the union territory administration or any authority specified in this behalf shall take steps to detect illegal migrants in India in accordance with the procedure specified by the central government from time to time, which may include the following, namely, examination of foreigners, inspection of any aircraft and such, inspection of any place of premises, in all these guidelines. So the Supreme Court has given certain directions within certain conditions. One of the conditions is that the state government submitted, and the London Advocate General also submitted in one of the cases cited by the petitioner, that the correctional home, separate correctional home for those who are convicted shall be established. And whether within 6 months there has been none or not. The UL also directed Mr. Sen, the London Additional Advocate General, to take instruction on this issue. That apart, even an address is disclosed, whether there is a scope for monitoring by the FRRO during the stay of the person till deportation, because the law is well clear, established and clear, that a foreigner who is convicted now has to be deported back to his own country in terms of this act, because he has neither a passport nor a visa, nor even a travel document.
Correct.
So therefore, the purported attempt to override the conviction order and all that by filing an application being rejected, and no 482 application was filed before the criminal court. Therefore, the petitioners are obliged to remain in India till they are deported. So till such deportation, there shall be continuous monitoring by the FRR.
Correct.
That is the object of the act.
Correct.
These are the things Rasta will kindly do.
That's why my
That will come
on
later.
that last day this court has brought the opinion.
Yes.
But what about the order passed by the Supreme Court?
That is for the London Advocate General to say.
I've spoken to the Chief Secretary yesterday, but I would require some time because they'll have to pass on instructions to me. But I would request your Lordship keeps it on the reopening date. In the meantime, as has fallen from the court, but we'll verify the particulars of this address and come back. Your Lordship need not pass any order. I'll come back with better instruction and more particularly about these addresses.
Because now your advocates appeared before the Supreme Court has made some submission.
Yeah, I've seen that order. I've seen that.
Then there might be instruction from the state government.
That's why
without the instruction, he will not submit before the Supreme Court.
Because these are important policy matters. Therefore,
that's why I am also taking strict on since so.
But about Degonga, the address disclosed by the petitioner, I have objection. Because this is border area.
You make objection. That's why they have provided. I will direct the state to verify the address.
No, kindly do not pass any order. I'll verify and come back.
No, not only state. Kindly also.
Then you will not come. Other advocate will come.
I take responsibility. Keep it on.
Not only
state. On the
state.
reopening day,
Kindly also direct the FRRO who are made party by your lordship to also inspect simultaneously about the address.
Yes, the FRRO and informs my lord.
FRRO should be directed also to inspect the address disclosed.
Howrah GRPS, my lord, I have.
In terms of the order dated 22nd December 2025, the petitioner has forwarded the address. If the petitioner is from the correct petitioner has communicated the address. If the petitioner is released from the correct petitioner will reside in the said address. The said address has been forwarded to the state authorities as well as the FRRO. Police.
No, this has not. I don't know whether it has been communicated to FRRO.
No, it has not been communicated.
No, it has been communicated to superintendent.
Kindly see, sir. Kindly see. That is the problem. Kindly see the mail.
To both, my lord. It has been communicated.
This copy was not given to me.
Right now it is.
Right now it is given.
Okay, whatever. Give the letter here. Full stop. Forwarded to the state authority as well as FRRO. Full stop. London Advocate General submit that he will take appropriate instruction with regard to the said address. Full stop. The DSGI appearing for the Union of India submit that FRRO may also be directed to inspect the place which the petitioner has intent to reside after if he is released from the correctional home. Accordingly, the FRRO is also directed to verify the address furnished by the petitioner.
And also whether it is convenient for FRRO to inspect the border area.
The FRL is also directed to verify the address furnished by petitioner, and it is feasible. It is feasible that the petitioner can be allowed to reside in the said address. Let the matter appear on 5th of January 2025 under the same.
My lord, if I may be allowed to just add the care of, my lord, because it came from
The petitioner is given liberty to add the name of the person whose care of the petitioner will be residing if he is released. If he is released from the correctional.
grateful. My
Yes, yes, you provide all the.
But parties should be granted liberty to communicate the order to respective parties.
The petition is directed to communicate this order to all the parties.
And they have to act on this.
Compliance. For compliance.
ঠিক আছে স্যার, ওইটা করে আমি দিয়ে দিচ্ছি।
Yes, next.
Grateful.
Item number 3 is for extension of interim order.
Yes, 6. Who is for the 11 AM? Nobody is there.
I beg to appear on behalf of the petitioner.
Yes.
May I file the affidavit of service? Or my lord may take it up at 12, my lord. That other rally matter, my lord, has fixed, my lord. I
Taken at 2 PM.
Yes.
Eh,
Relate almost
12 noon, 12 noon. Password is
12,
12 noon.
12, 6 though. 6, sir. 12টার সময়
Other matter is also fixed.
That one is a challenging a rejection order. This is non-consideration of.
Ready? I will take the.
Yes, yes, I'm ready.
Yes.
May I file the affidavit of service? Here the rally, the meeting, my lord, is on private land. It's scheduled on the 28th of December. Application intimation was served, my lord, on the 20th of December. My lord will find that at page 28, made to the SDO.
28.
Yes, my lord.
2012.
2012, 2025.
Yes.
The expected turnout is, my lord, around 5,000.
Yes.
My lord, we have also, my lord, enclosed to the petition, my lord, the list of volunteers, the sketch map,
Yes.
and my lord, the no objection received from the lessee, who is, my lord, in possession of this land, my lord, which is a hut. So we have annexed that also, my lord. So the state, my lord, in terms of their usual practice, my lord, till now they have not responded. And my lord, it is also stated that the practices or the modus operandi is, my lord, that are in either in the wee hours, my lord, they will, my lord, visit us with a rejection on the 27th night, or, my lord, they will, my lord, post some more queries to frustrate, my lord, this particular meeting.
Yes.
In fact, my lord, I will be referring to an order passed by your lordship yesterday, that is on 23/12/2025, wherein my lord was pleased, my lord, to direct the SDO to pass an order and communicate the same by 10 PM, my lord.
Yes.
Despite the, my lord, observations made by the honorable court, my lord, it has been rejected on extraneous consideration, my lord. Challenging with, my lord, the matter is pending today at 12, my lord.
Okay.
So, my lord, I was relying on, my lord, the judgment of, my lord, this is the judgment, my lord, of yesterday, my lord, which I am relying upon. And এটা দাও ডিভিশন বেঞ্চেরটা দাও অনিন্দ গোপাল মিত্র, হ্যাঁ। But I was referring to, my lord, a division bench decision reported in 1993, 1 Calcutta Law Times, page 464. The relevant paragraph is, my lord, paragraph 4. That says, my lord, that in appropriate cases, the honorable court, in exercise of powers under Article 226, can pass mandatory orders directing performance of a duty, my lord. This is again relying on, my lord, Comptroller and Auditor General of India versus K.S. Jagannath. And that apart, my lord, in similar matters also, my lord has passed similar orders granting permission
Yes.
But in one such similar matter, my lord was pleased to, my lord, grant permission, my lord. I am relying on these, my lord, and but I am beseeching my lord to pass similar orders, my lord.
Yes.
Because the essentially, my lord, it is the duty of the SDO. There is another prayer also, my lord, to ensure that it's not obstructed in any manner whatsoever. Direction upon the
Yes.
respondent
But
authorities,
as
my
far
lord.
as Malad, the second part which he has just annexed to his main argument, your lordship has dealt with it in yesterday's order, which my learned friend has already handed over. Malad, your lordship has Malad, considered this, whether prayer B is to be considered or C is to be considered, or both. So Malad, I presume that he will only place prayer B, which is for the microphone permission, Malad. So due to paucity of time, I could not get a signed copy, but I have obtained it digitally, Malad. So Malad, this is the written instruction of the SDO, Malad, who says that he has received the email, Malad, on a weekend, Malad. So, Malad, it could not be considered up to Monday. Hard copy of the application has only been received on 22nd. He has already, Malad, sent it to the BDO, whose report he has obtained, and also to the police, who will hold a field inquiry. He has prayed time till 26th of December to pass necessary orders in apropos to his application. May your lordship, Malad, yesterday in another matter has passed an order to given to upon the SDO to pass an order within 26th of December, Malad. The same order may be passed, Malad, upon the SDO to consider his application by 26th of December.
Yes.
Now, Malad, as far as Malad, the CLT judgment is concerned, Malad, that is, Malad, probably of no avail to the petitioner, because the mandatory duty that he beseeches your lordship to direct us, Malad, his prayer is limited to a microphone permission only. Though, Malad, he cannot go beyond his prayer today by citing that CLT judgment, Malad. That is not applicable in his case at all. Therefore, Malad, your lordship will kindly direct the SDO to pass necessary orders by 26th of December.
His prayer with regard to the use of microphones, speakers, and holding meeting in the private land. Correct, in the private
Yes.
land. So let this be allowed, and the authority will take care of the law and order problem. It's
He has not come with for a permission for the rally before your lordship. He has come for challenging
not really. Kindly come to the prayer B. Grant permission to the petitioner and his organization to use nature mandamus commanding the respondent to forthwith grant permission.
Grant permission.
Correct. Grant permission for speakers and the holding this. So I will allow the petitioner to grant permission subject to take the precautions of the land situation of the.
But if your lordship,
again question.
But if your lordship, Malad, direct them grant microphone permission in a 226 jurisdiction, Malad, that will be robbing the SDO of his powers, Malad, to pass an order. Before him passing an order, Malad, if your lordship passes the order, Malad, then his exercise, his subjective satisfaction, Malad, becomes immaterial, Malad.
Correct, but what can be done if the court is passing an order, consider, and the authorities yesterday what has been done? It has been done the same
that
thing.
matter is not,
not done. That's why. That's why
the factual aspects.
That's why the
whether the rejection order has been placed before your lordship or not, Malad. Here it is. There is no rejection at all, Malad. So, Malad, that matter kindly do not, Malad, judge this matter, Malad, on the foundational facts of another matter, Malad. But why it has been rejected? Well, the rejection order has to be placed.
When it is matter is on 28.
This meeting is on 28.
28. Today we are on 24 because there is
one more working day, Malad.
There is no court also. If you reject, what will happen? There is no court. Vacation is on.
They'll seek leave, Malad. But it's not that, Malad, the High Court is closed for eternity, Malad. It is only that scheduled vacation benches are there and they can always approach. But your lordship will kindly not presume that the SDO will reject the matter.
The act of the authorities, from FSI, this court has made an opinion, the authority intending to reject the applications in spite of the direction passed by the court. What has happened?
Then, Malad, with the deepest of respect, Malad, your lordship will have to hold that because there is a rejection in another matter, your lordship is...
Yes, I will record that. I will record that also.
That your lordship presumes that the SDO will reject in this case also. And that is why, Malad, the SDO should not be given...
Or I will fix the matter at 3:30 p.m. You take the report whether you receive the report from the BDO or not.
BDO, yes.
I am fixing the matter.
He has said he has received from the BDO.
Yes, then I am fixing the matter at
but
3
the
p.m.
field inquiry by the Malad, field inquiry by the police is awaited.
The matter at 3:30 p.m. You come with the report of the SDO whether he is going to allow or not. Then I will pass appropriate order. If you don't want that the court can pass a mandatory order, then I will fix the matter at 3:30. You tell, yes, this is the against the report. Then I will direct the petitioner, whatever it may be.
Then Malad kindly passes an interim order Malad, for directing the SDO to pass the order today by 3 p.m. rejecting my prayer for 26th December.
What, if you are telling that the SDO will pass an order.
By 26th of December, Malad, the field inquiry is not over.
That's right. And
Malad, a congregation of 5,000 people, they come up on a Saturday, 20th, they send a mail at 2:58.
it is a state duty to take all
We are
the
doing it, Malad. Malad, we are doing it. But Malad, your lordship is asking me to pass the order within 3 p.m., rejecting my prayer to give me time till 26th of December. Your lordship will pass that order, Malad, kindly.
If you say that you will bring the order at 3:30, either rejection or.
But I don't have the,
you
Malad,
come
the
at
instruction I have already placed with your lordship, Malad. Malad, kindly, Malad, if I may put it in a question form, Malad, can I go beyond my instructions also, Malad?
Correct. That's why the court can go.
No, your lordship is not bound by anyone's instructions, Malad. Your lordship will apply your lordship discretion. Your lordship is in a discretionary jurisdiction. Malad, if your lordship, Malad, desires that I place the order by 3 p.m., Malad, I'll have to place that order before that there's a direction by the court. You give me the order by 3 p.m. because he has asked for time till 26th of December.
25th, there is no problem giving the time even on 27th, but there is no court till 20th.
Malad, if your lordship, Malad, judges this matter by a rejection of another matter, lordship will kindly hold that because I cannot better my argument with regard to that.
I will pass an interim order holding that also. No
Well,
problem.
that interim order will amount to a final order because Malad, because the matter will become infructuous thereafter, Malad. But that interim order will amount to a final order. So, Malad, if your lordship, Malad, I'll, Malad, as an officer of the court, I'll beseech your lordship, Malad, not to judge this case on the basis of a rejection of another case because the ground realities of each case are absolutely different. The situation in each area is completely different. And your lordship will also remember in one of the matters, your lordship held that don't do this part of the meeting, do other part of the meeting.
Correct.
So therefore, Malad, it is every case is not the same, every
Correct.
fact
That's
is not
what
the
I'm
same.
That's why I'm telling you could have been come the report.
I could not. The hard copy has been given on 22nd of December. But kindly put this question to the petitioner that you are holding a rally for 5,000 people or sometimes 10,000 people, 15,000 people.
20 December, not 20.
That is a Saturday, my lord.
20 December.
That is a Saturday by mail. But it's a government office. No one is sitting with the computer and the mail to check all the applications. Kindly see the SDO says that I have received the hard copy on 22nd. Immediately I have forwarded to all the authorities.
Correct.
And also I have got a report from the BDO. The police field inquiry report is awaited. Tomorrow is a holiday. He has asked time till 26th of December. Your lordships are being apprehensive that since there is a rejection in another matter, the SDO of another SDO will also reject the same.
Correct.
Then Malad will kindly pass that order, Malad. I cannot better my argument with regard to that.
Petitioner has filed the present writ application praying for a direction upon the respondent number 2 to grant permission to the petitioner and his organization to use microphones and speakers during holding the meeting, which is scheduled to be held on 28 December 2025 from 1000 hours to 1700 hours at Bakra Hachali Madan, situated at jail number 125, tag number 637/788 under the Shankarel police station. Petitioner submit that the petitioner has applied for grant of permission on 20th of December 2025, along with the no objection from the person who no objection of the person who, in whose name the land is recorded.
Lessee of the land.
Lessee of the property in question. Full stop. The petitioner also given all the information along with the application. Full stop. In spite of the receipt of the said application, comma, the sub-divisional officer has not granted permission. He further submit that today is the last working day of the court and the meeting is going to be held on 28th of December 2025, and in the meantime there will be a no court if the request of the petitioner is rejected by the petitioner by the authority. Accordingly, he prays for an order directing the respondent number 2 to grant permission to hold the meeting and use the microphones and speakers. Learned counsel appearing for the state raised objection and submits that though the petitioner has submitted the application on 20th December 2025 by email, but 20th December 2025 was Saturday. He has submitted the unsigned copy of the report received from the office of the sub-divisional officer, wherein it reveals that, and on the basis of the said report, he submits that on receipt of the application Immediately, the sub-divisional officer has called for the report from the concerned BDO as well as the officer in charge of the concerned police officer in charge
Officer in charge, my lord,
of the Sankarkali police station. Please further submit that as per the said report, the sub-divisional officer has received the report from the block development officer, but he is awaiting the report from the police authority. And once he will receive the report from the police authority, he will pass appropriate order by 26th of December 2025. And petitioner submit that as the matter is pending before the authority, and as such, no order can be passed at this moment. Full stop. At the Leonard Court, full stop. The petitioner, in support of his submission, has relied upon the judgment in the case of State of West Bengal and others versus Dr. Anindya Gopal Mitro and others reported in 1993 SEC Online Calcutta 126, and submits that in the division bench of this court has held has directed the authority to held that the authority how to be allowed permission as sought for by the petitioner by imposing all such reasonable restrictions and regulatory measures as the authorities think fit, so that no breach of peace take places. Petitioner has further relied upon the unreported judgment passed by this court in the case of Rajesh Jana versus the State of West Bengal and others, dated 23rd of December 2025, wherein this court has allowed the has directed.
That is Debashish Samanto, my lord, the other one.
No, you have given the Rajesh Jana.
No, Debashish also have given, my lord, Rajesh to cite, my lord, the vindictiveness of the authorities, my lord.
Debashish, क्या बोला? Unreported judgment in the case of Debashish Samanto versus State of West Bengal in WPA 28348 of 2025, dated 10/12/2025, wherein this court allowed the petitioner to conduct the meeting fully as requested by the petitioner to the authorities. Fully heard the learned counsel for the respective parties. This court finds that the petitioner has applied for grant of permission for using microphones and speaker during the meeting, which is to be scheduled to be held on 28th of December 2025 from 10:00 hours to 17:00 hours as at the address mentioned above, at the place mentioned above. Full stop. The report of the sub-divisional officer reveals that on receipt of the request, the sub-divisional officer has received the report from the officer, but he is awaiting the report from the police authority, due to which the sub-divisional officer has not granted permission. Learned counsel for the state pressing for prayed for a direction upon the respondent authority to dispose of the application of the petitioner, so that the authority can dispose of the said application on or before 26th of December 2025. This court find that the similar submission was made by the state authority on the earlier occasion in the earlier other writ application, and this court has directed the sub-divisional officer to consider the petition and dispose of the application filed by the petitioner for grant of permission. But at the 19th hour, the authority has disposed of rejected the request of the petitioner. In this case, this court find that this is the last date of the last working day of this court before winter vacation, and the vacation bench will be held on 29th of January 29th of December 2025, and the petitioner intend to hold the meeting on 28th of December 2025. If the respondent will reject, if the respondent two will reject the request of the petitioner, the petitioner will not any forum to challenge the said order. Accordingly, this court, taking into special circumstances, this court allowed direct the respondent number 2 to grant permission to the petitioner and his organization to use the microphone and speakers during the meeting scheduled to be held on 28th of December 2025 when at 1000 hours to 1700 hours at the place mentioned above. Police. The authority is also directed, the petitions are all directed to by holding the meeting to keep to see that the law and order and the peace of the said area shall not be disturbed. Police. The authority is also directed to make necessary arrangement for proper law and order, maintenance of the law and order. Police. The sub-divisional officer is also directed to keep vigil and keep vigil of the situation at the time of holding the meeting by the petitioner on 28th of December 2025 from 1000 hours to 1700 hours at the place mentioned above. The petition, as the petition is disposed of in without calling the affidavit, the allegation made by the petitioner deemed to have been denied.
But since it is not a police in action, I was praying for a stay of the order till 27th of December.
I am countering it by saying that it's a public law remedy that I am seeking, and order 2, rule 3 will be rendered nugatory.
Petitioner has prayed for
Joinder of causes of action.
prayed for and the state has prayed for stay of the interim order on the ground that this court is not having the determination of the police or police inaction and non-action and action. This court find that the main prayer of the petitioner for grant of permission by the respondent number 2 is the sub-divisional officer, and this court has passed an order directing the sub-divisional officer to grant permission, and this court has not, even though the police authority, this court has passed any order against the police authority, the common cause of action can be dealt by this court.
Extremely grateful, my lord. Order 2,
Cause
rule
of
3.
action can be dealt by this court.
Grateful. Extremely grateful.
Accordingly, the interim order is refused.
Milord, I have kind indulgence to allow the leave of Jalpaiguri matter to be filed during the vacation bench.
Leave granted to the petitioner to file the writ application during the vacation. Fine. ठीक है, वो ऑर्डर खाली करना, खाली ऑर्डर करके वो फाइल तो वहाँ गया होगा ना, डिपार्टमेंट में गया होगा ना। सप्लीमेंट्री लिस्ट कितना बजे बोला? क्या पागल है आप? कॉल करो लिस्ट।
And for the petitioner, on 25th of March this year, the initial interim order was passed, whereby my lord, the order dated 20th of January 2025, passed by the Honorable NGT was stayed. But that said interim order was extended on 16th of November 2025, but it was subsisting till 19th of December, my lord. We had mentioned the matter prior to 19th of December. For some reason, but the matter could not be taken up. But we are only praying for a limited extension, my lord. The affidavits have been exchanged, my lord. Your lordship may, my lord.
When the interim order was passed?
16th of November, my lord, it was last extended, and the initial order was on 25th of March 2025.
Yes. Which was the authority?
My lord, I beg to represent the state, my lord.
Yes.
Lordship may kindly have a look at the last order dated 16th September 2025, when the interim order was last extended till 19th December.
Yes.
We are on 24th.
But we had mentioned on, my lord, prior to 19th, my lord, your lordship had directed the matter to.
So as on date, it can't be said extension, it is reimposition. It is reimposition, not extension.
Yes.
Well, this matter was mentioned by us before your lordship prior to 19th. Your lordship was pleased to direct the matter to appear prior to 19th. For some reason, my lord, the matter could not appear, my lord. Thereafter, we again mentioned, and today the matter is appearing. So, my lord, there is no laches on the part of us, my lord. If your lordship so desires, my lord, we can file an application for extension, my lord, and come up after vacation. But, my lord, if your lordship so desires, my lord, can.
What is the nature of the interim order?
Staying, my lord, the order wherein, my lord, the property of the petitioner was sought to be demolished by the NGT, my lord.
My lord, that your lordship will get from order dated 25th March 2025. 25th March 20, paragraph 16, Lordship may kindly have a look at Lordship. 25th March 2025 order, paragraph 16. The direction passed in paragraph 81 of the judgment passed by the learned tribunal. on
Paragraph 4 read with paragraph 16. My lord.
Be kept in abeyance till 30th June.
Affidavits completed.
Yes, my lord.
Affidavits have been exchanged, Lordship.
But my lord, the main authority, my lord, who is supposed to answer the queries, my lord, put by the honorable court on the last occasion, they have not filed their affidavit. The wetland authority, my lord, they are the main authorities, my lord.
The state has filed opposition.
Yes, my lord, we have given our reply also.
Yes.
Petition, the matter is listed as to be mentioned for extension of the interim order. The counsel for the petition submit that initially the interim order was passed initially by an order dated 25th of March 2025. This court has passed an interim order till 30th June 2025 or until further order whichever is earlier. Subsequently, the interim order was extended from time to time till 19th of December 2025. Before 19 December 2025, the petitioner has mentioned the matter before this court, but inadvertently matter was not listed. Subsequent again the petition was mentioned the matter and the matter is listed today, and he pressed for extension of interim order. Full stop. Then advocate appearing for the state raised objection and submitted that the interim order granted earlier is up till 19th of December 2025. As on today, there is no interim order. And as such, the interim order cannot be extended, which is expired on 19th of December 2020. He further submitted that the petitioner hinted that the interim order granted earlier on 25th of March 2025 is to be extended. Then it is to be, the interim order is to be reimposed, and that cannot be reimposed without any application. Heard the learned counsel for the respective parties, this court find that initially this court passed an order of interim order directing restraining the keeping the interim order dated 30th June 2025, keeping the order passed by the NGT on 21st of January 2025 in abeyance. This court found that the time and again the interim order was extended. It is the petitioner has mentioned the matter, but inadvertently matter could not be listed. Full stop. Full stop. It is also found that the affidavits have been completed. The matter is ready for final hearing. Considering the above circumstances, the interim order is extended till, give the date, 2 p.m. कौन सा date खाली है?
সবাই তো অপোজিশন অ্যাফিডেভিটে
12th February at 2 p.m. as a specially fixed matter. Interim order is extended till 12th February 2026 or until further order, whichever is earlier.
Lordship.
Yes.
My last appearance of the year before your Lordship.
Happy New
Happy
Year.
vacation, happy New Year to your Lordship.
Thank you, thank you.
And your lordship has been pleased to fix the matter on. Your lordship has been pleased to fix the matter on, my lord.
2 p.m. क्या डेट बोला? हाँ? बोलो. 12th February as a specially fixed matter, come ready. Otherwise, no interim order.
Grateful, your lordship.
Item number 4, Your Lordship, I am for the petitioner, Your Lordship. In the order, Your Lordship, that paragraph number 1, Your Lordship, the impugned order dated 20th January 2025, but it is inadvertently recorded, Your Lordship, that 20th January 2024.
Where?
Paragraph number 1, Your Lordship.
Paragraph number
1. Order
20th
20th January 2024, but the impugned order dated 20th January 2025, Your Lordship. 20th January 2025, Your Lordship. But it is inadvertently recorded, Your 2024, Your Lordship.
So what is the actual date?
Actual date 20th February 2024. 20
Year is 25.
25.
That's all.
That's all. And another, Your Lordship, that paragraph number 2, Your Lordship, probably it is a part of the order of the honorable tribunal, Your Lordship. But it should be, Your Lordship, maybe it is a quote unquote, Your Lordship. Otherwise, Lordship, it is a view of the honorable court, Your Lordship, in this order. Because in view of the matter, we can allow.
Okay, recorded.
And
it is listed as to be mentioned for correction in
Lordship, another correction, Your Lordship.
No correction is required. Yes, next call the
Lordship, paragraph number 8, Your Lordship.
Come after vacation. Yes, call the list.
My lord, in that matter, I am appearing for the plaintiff, petitioner, my lord. My lord, due to the jurisdictional issue, your lordship had released this matter. Only the CAN application has been released. Yesterday, I have mentioned the matter. The WPA is not in.
By an order dated 2nd December 2025, this court has released the writ petition along with the CAN application, but inadvertently in the order dated 2nd December 2025, it is recorded that the CAN 1 of 2025 is released from this list of this court with the liberty to the petitioner to mention before the court having determined. In view of the above, the order dated 2nd December 2025 is modified by releasing the writ petition WPA 18729 of 2025 along with CAN 1 of 2025 from the list of this court with the liberty to the petitioner to mention before the court having determined. Next.
May it please your lordship, my lord. Lord, before I take my lord to the pages, I'll just give 2 minutes background of the matter. Lord, I have challenged order blocking me from participating in a tender. Now, Lord, the matter has a history. Lord, I participated in an earlier tender in 2016 for Lord, lifting of scrap material from Sale Bokaro. Lord, when I asked for a completion certificate, they, my lord, issued a banning order on me. I challenged that before my lord. Justice Sabyasachi Bhattacharya allowed my writ petition. They took a point of jurisdiction, took all points. Justice Sabyasachi Bhattacharya allowed my writ petition. Then they gave me a completion certificate indicating the banning order. Then we challenged that completion certificate. Again, Justice Bhattacharya allowed our writ petition, setting aside the completion certificate. They went up in appeal. They lost before the division bench of Justice Sivagnanam. Over. Then they issued a further show cause notice because Justice Bhattacharya says this will not stop them from proceeding in terms of law. That show cause notice was challenged by us before Justice Shampa Sarkar. Justice Sarkar stayed that show cause notice, said we don't need to even answer to that. Your lordship on 19th of December has extended the interim order in that matter. So 3 writ petitions on 3 matters, I got protection. There is no order banning me, stopping me. Lord, kindly take page 135 of the writ petition. 135 the book. Last document is 143. 143. Take page 143. Lord, I have a fresh page for your lordship. Just down.
143.
Yes, last page of the volume 1.
Yes.
My lord, it's a colored copy. My lord, will see at the top there's a red dot on the left after the print preview. Here, print preview, red dot. Just below display. Kindly see vendor code number so and so is blocked. Please contact procurement agency. Lord, kindly take page 16, paragraph 4V. After they issued a new page 16, paragraph 4V of the writ petition.
Page 16.
Page 16 of the writ petition, para V, Roman V.
Yes.
The petitioner has duly registered themselves on the online portal respondent in order to submit their bid. This is the number generated. Not I have tallied the number, it is the same number. It is the same number.
Portal respondent authorities to submit their bid online and the vendor number.
My lord, may tally it with the document I have given.
6947. Yes.
76497. My lord has seen that. So they floated a tender. My lord will take the date and page number. They floated the last tender. Lord, new tender at page 76 on page. Now kindly take page 76. Page 76.
Yes.
This is the new tender floated by them on 4th of November. My lord has seen that.
Yes.
My lord, the scope of work you also will get at Lord page 78.
Yes.
Scope of work, my lord may have a look at. Scope of work, digging, excavation of slag, scrap, muck, debris from slag pits and various bays of SMS.
Where is the scope of work?
Lord, page 78.
78.
78. But I'm sorry, I. Preamble of the schedule of work, page 78.
Yes.
Then kindly come to scope of work 4A. digging, excavation of slag, scrap, muck, debris, slag pit, various bays, transportation slag, so and so. So they floated a tender, not whether I'll get it or not, that's subsequent. The submission date was in page 76, you will get the submission date at page 24. 24th November was the submission date.
24th November.
24th November. Now wait, 24th November, page 76. Page 76. Under tender head, kindly see. Bid submission deadline 24th November. This was extended up to 18th of December. I'll show that.
Yes. 18th
Now,
of December.
24th November, 18th of December.
Where it is?
My lord will get that at page 168. My lord, may we see that second volume on barcode page 168. I'll see.
Extended till 18th December.
So, my lord, till 18th December the date was there. Initially 24th November. My lord, kindly take now page 98. My first representation. That will clear all doubt. Page 98. Kindly take page 98.
Yes.
No, kindly allow me to place.
When it was blocked. When
It was blocked. Lord, we have made the representation on 21st November.
No. This page 43. When you got this block.
Lord, it must have been before 21st of November because 24th was the last date. So we approached them before that. Kindly take page 98 once.
Yes.
20th we have tried, 21st. Not kindly allow me to place this because this refers to all earlier order. This is to inform you that we intend to participate in the aforesaid tender. However, when we checked the online tender portal, we found that you have blocked us from participating in the tender. In this regard, we would like to draw your kind attention that we had previously participated in a previous tender number so of 30th November 2016 and successfully completed the contract. However, SAIL Bokaro had allegedly issued suspension order on 12 June 23 against Amit Mines Private, that's the petitioner, suspending future business till 11 December. Further order that as per clause so tender document the order of suspension would operate as such the said suspension order came to have been effect. Then can you take the next page? Moreover, AMPL had duly challenged the said suspension order dated so by a writ petition being WPA 14533 before the Honorable High Court at Calcutta, and the said Honorable Court by judgment dated so set aside the impugned suspension order. Part of the record, I'll show it. Then, thereafter on 21st June, SAIL Bokaro issued a completion certificate to AMPL, wherein under para 6 of the certificate, noted AMPL is being suspended from all future business dealings for 6 months. So, copy of the said communication is Annex C. The said impugned completion certificate was also challenged by AMPL VD WPA 18564 before the Honorable High Court at Calcutta. That on 12 October 23, single bench passed its judgment, set aside the impugned completion certificate dated so, directed SAIL Bokaro to issue a fresh certificate. Copy is annexed. SAIL Bokaro, being aggrieved by the judgment dated 12 October, preferred an appeal before the division bench before the High Court at Calcutta, mat number so and challenged the order dated 12 October passed by the learned single bench. On 24th April 24, the division bench passed its judgment and upheld the order of the Honorable Single Judge and directed SAIL to comply with the order of the single bench within 6 weeks. Copy annexed. As a consequence thereof, on 8 July 24, a job certificate was issued. However, the said compliance certificate was also defective. So kindly turn the page. Further, to this SAIL Bokaro issued a impugned show cause notice dated 15 June. AMPL copy show cause notice annexed. The same was again challenged by AMPL in WPA 17610 before the High Court at Calcutta, and the Honorable Court White order dated 9 July 24 directed AMPL need not reply to the show cause notice, and that the said interim order of injunction has been lastly extended till 19 December. In view of the aforesaid, SAIL Bokaro has no valid reason to block AMPL from participating in the tender dated the screenshot of blocking AMPL having vendor code number is enclosed as J, which I have shown. As such, you are requested to unblock Amit Mines. This was on 21st of November. They did not do. My lord, take note of the next page. We send another document at page 142. On 24th of November itself, page 142, my lord, may just mark the page. Page 142, sorry, it is in the first volume, my lord, page 142.
Yes.
142. No. Sorry, 144, my lord. I made a mistake in my note. 144. I'm so sorry, my lord. 144, volume 2, first page. 24th November, we sent another email.
45.
144, 145 is the second date extension. 144 is the representation. In reference to the above, dated 21st November, we once again request you to unblock Amit Mines on the tendering portal to allow us to participate. Let us got that. Then they extended the date, 145.
18 December.
Till 18, no, this is not till 18 December. They extended till 12 December. Page 145, extension till 12 December.
Where it is? Yes, 12 December.
Yes. Then what we did, Milord, we made another representation at Milord page 167. এখান থেকে page গুলো বার করে দেন। Page 167. This is on 1st of December. Since it was extended to 12 December, that please allow us to participate.
Yes.
Then, Milord, the bid submission was extended till 18 December.
Yes.
Now, Milord, kindly take only one paragraph of the writ petition. Page 19, para DD. Page 19 kindly comes. I have named the officer. He called me for a hearing. He made me sit in his office, said that we are unblocking you and made us cross the deadline. Kindly come to page 19, para DD. Lastly, despite several requests made by the petitioner to the respondent authorities have not unblocked the petitioner in order to make them participate in the instant tender proceeding, due to which petitioner again spoke to Mr. Rakesh Singh, CJEM Marketing, Chief General Manager Marketing, who has called the petitioner's representative to meet him on 18 December 25 to help the petitioner to resolve the dispute, the last date, and to help the petitioner to submit his bid. But after the petitioner reached the office of the said Rakesh Singh, the petitioner's request was not cooperated at all with, despite the petitioner being assured several times. Although throughout this whole period, the respondent authorities have assured the petitioner that such unblocking of the petitioner in their online portal shall be made and the petitioner shall be allowed to participate in the instant tender proceeding, but despite such repeated assurances, no steps have been taken by the authority. We duly showed that the respondent authority intentionally misled the petitioner. Petitioner cannot approach, which they could not do directly before Justice Sobhyasachi Bhattacharya first time, before the division bench second time, before Justice Sampa Sarkar third time. They have done it indirectly. May I give you also the page number of the judgments? Kindly note, Milord, Justice Bhattacharya's first judgment is at page 34. Take page 34, Milord, once.
Yes, next page.
Page 34 is the first judgment, Milord. This is concerning, take page 34, this is concerning, Milord, the completion certificate. Milord, only one thing they could point out about the jurisdiction. Milord, initially they took the point that sale Bokaro is beyond the territorial jurisdiction, the writ is not maintainable. Justice Bhattacharya has dealt with that. Milord, take the second judgment of Justice Bhattacharya, page 42, challenging the banning order.
Yes.
Challenging the banning order which was taken up in appeal.
Yes.
Lord, kindly take the jurisdiction point they took at para 12. Para 12, page 45. The first objection pertains to territorial jurisdiction of this court to entertain the petition. It is pointed out that respondents are primarily located in the state of Jharkhand. Impugned decision suspensions were also taken by the Jharkhand for order in Jharkhand. Hence, only the frivolous pretext communication or suspension order received by the petitioner in Kolkata, jurisdiction of Kolkata, cannot be invoked. This was the point taken. Can it come to para 22 of the judgment, Milord, at page 47. Para 20, sorry. Para 20. Dealing with the issue of maintainability first, it is to be noted. Para 20.
Yes.
Page 47. Dealing with the issue of maintainability first, it is to be noted that the averment made in the writ petition are to be considered ascertaining territorial jurisdiction. It has been pleaded by the petitioner that the cause of action partially arose within the territorial jurisdiction of court. Address of the petitioner in Kolkata, meaning the petitioner received the impugned order banning suspension in Kolkata. That apart, it has been pleaded that the petitioner has suffered and continues to suffer in Kolkata. Thus, we find from the averment writ petition, the arguments of the learned advocate counsel for the petitioner receives so. Milord, the concluding part will also will get at Milord, para 27. Para 27.
Yes.
Sorry. But I'm sorry. Para 27. Since the petitioner alleges infringement of the right of the petitioner to participate in the similar tender all over India, including West Bengal, and rights are flowed under Article 19 Constitution, it can be very well said that the part of legal and constitutional right of the petitioner and his directors and other functionaries as well as his employees is infringed within the jurisdiction. Same cause of action is here. Now, this was carried on appeal The appeal court judgment, my lord, will get page 59. And one more interesting thing I should show your lordships. Kindly come to page 57 once. Justice Bhattacharya's single bench judgment. The court was categorical that they are proceeding mala fide, para 51. Mala fide can also be attributed to the respondents since the timing of suspension order is crucial. All along, respondents have been granting extensions to the petitioner without raising issue of delay. Only after the petitioner completed the work insisted upon so and so. So mala fide was also taken into consideration. Page 59, division bench. Sale went up in appeal, sale lost. And that is the second round. Sale lost in the appeal. Appeal was disposed of without interfering. My lord will get that at page 63, para 14. Therefore, we are of the view that the impugned order doesn't call for any interference. My lord has got that?
Yes.
Then what they did,
Yes, what is the
they issued a show cause, that is state.
what is your stand?
Firstly, they have been aware since 20th November that their vendor code is blocked.
Yes.
They are aware since
Mic
20th
turn,
November.
mic turn.
They are aware since 20th November that pleaded at page 17.
Correct.
Thereafter, they have sent at least 4 emails.
Correct.
And they have filed a writ petition on 19 when the tender was opened. After all these were done.
Correct.
My first point is, my
So,
lord,
show the decision. If he has given the series of the representation, you have taken the decision.
Yes, decision.
And you have opened the tender.
Yes. You
Show me the decision taken by you. I will right now dismiss the writ application. Have you considered the representation and thereafter you have proceeded with tender process? I am asking you when you are officer. I let you call appear before this court at 2 p.m.
Yes.
Playing with the court's order. You are not advised. Once the court has passed an order of stay of the banning, can you block this? Even after the order of the division bench, then take the instruction whether you will unblock or allow, or otherwise I have to pass an appropriate order. After rule so moto, I will issue the rule here. You know. Take the instruction. You have 2 options. Either you show the order that you have passed an order on the representation before you opening the tender, or you come with the instruction that you will allow this unblock, you will unblock and allow, take the tender of the petitioner for consideration. I am not telling that allow the work order. But take the consideration.
Yes.
Because there is an interim order. And you have not appealed the interim order, there is no stay. There is binding upon this court, binding upon you, binding upon the petitioner. Huh?
there is no
No order.
pursuant to their representations. There is
No order. Then how you can proceed blocked? How you can block?
my instructions are that whenever a suspension procedure is initiated, the vendor code is
Correct. Blocked. But the court has passed an order for a stay. What is the date of the order?
the date of order 9 July 2020.
9 July 20. When you block this? Huh? Then, so once the court has passed an order, you have to be unblocked.
এটা মাইকটা নিয়ে জোরে বল জোসেফ, শুনতে তো হবে, মাইকটা চালু কর।
That is at page 66 that they need not reply to the show cause notice.
That court has passed
Yes.
not to give and
Not to give
stay.
any reply.
The Justice Sarkar has passed an
Yes, absolutely. Lord.
It's 66.
Yes.
Yes. Justice Sarkar, so show the Justice
Page
Sarkar's
6,
order.
Lord, kindly take that order. Page 66.
Yes.
I have got a protection. 65 is the show cause. Page 66. Kindly take the last line. The petitioner need not reply the show cause notice till next date of hearing. Page 67, last line. Petitioner need not reply to the show cause notice till the next date of hearing.
Need not reply the so-called notice to the next.
Then there was a contest, and upon a contested order, kindly come to page 70, the next order. Page 70. This is order at 24th July, second last paragraph. Petitioner will not be required to reply to the show cause notice till the next date. Point of maintainability kept open. Then it is you will see extended on 19th of December. This is the last extension.
Either you tell
Because
you will not proceed the tender process. I will fix the matter for specially fix some in the month of February.
Yes.
Or either you unblocked and allow take the consideration of the tender of the petitioner. There are 2 options. Either you take. That's what I'm telling. I am giving an opportunity. You take instruction. 3, you have submitted that the representation has not been considered. This order has not been appealed for. Correct. There is an appeal order, need not to give the reply, and the stay is passed. Order of stay is passed. Correct. Now he has issued the tenders. He has applied for unblock. That is unblock. He has challenged. Block is he has challenged. Block he has challenged. So block he has challenged. That has been stayed. So what remains?
Only one thing is the territorial jurisdiction.
Huh?
Territorial jurisdiction.
That has been decided up to division bench.
May I just
Yes, yes.
what-
Tell me. I am asking you.
in the order that my learned friend showed, there was a challenge to the banning order show cause notice which they had received within
Correct.
jurisdiction.
Correct.
Here they are challenging an online bid invitation.
Not necessary.
Then also I have received it here from my office.
What is the see, what has happened? Initially, you issued the completion order with the rider, 6 months
That was
banning.
set aside.
That was set aside.
Set aside.
That
Appeal
was happened by the Honorable
Division
Appellate Court. Subsequently, again banning order,
No.
Set aside.
Show cause notice.
so cause notice for banning.
Yes.
So cause notice, that's what set aside. That
Yes,
was
first
set
Sokos set aside. Sokos, yes.
Jesse Bhattacharya,
Uh-huh.
set aside. Maintainability has also been
Yes,
decided with
yes,
the
yes,
jurisdiction.
yes.
Second order. Third, again you issued this.
Yes, Sokos. Third
So
Sokos.
cause
State.
state need not to give the reply. So where is the block? Where the block comes?
Power to block. Where is
Where
the
the
power?
block comes? Which order the blocks come? Once the banning order gone.
Yes.
Once the banning order gone, so how you can block?
Yes.
My instructions that I've already said, my lord, whenever this process is initiated, this blocking is done so that after the process of banning, they may be banned, may not be banned. They're called for a hearing, all that is done.
Correct, correct.
May be banned, may not be banned. In the meantime, if they succeed in the tender and then thereafter they are banned.
So that's why I'm giving option.
Hmm.
That's why I'm giving option. You have filed the affidavit in opposition. No,
First time.
No,
the
in the
first time. That's why you're giving option. Either you take instruction, you will not proceed the tender
yes,
process.
that's it.
Process, and I will
Already
fix a short date. Within 2 weeks, you give the reply. Within 1 week, he will give the affidavit. He will give the reply. And till that, no problem.
Lord, the other matter, my lord has fixed on 5th of February.
Yes.
For final disposal, specially fixed.
I will fix.
So till that time, let them not proceed.
Whatever as per the diary, I will fix a
Yes.
specially fixed matter.
Just let
So
them not
matter
proceed
can
with the
be heard
tender.
it out.
The tender will be blocked for till February.
Then?
But if my lord directs them us to, they can participate subject to the result of the.
No, that's it. Your apprehension is suppose he been allowed to participate. You will consider the document. Tomorrow, suppose he has been selected, and this writ petition will dismissed. Then what will be the effect of the work order issued if the work order issued?
The entire thing, because
So
it
that's
was-
why I'm telling.
No, the instruction is.
I am fixing at 2:30. You
Yes.
take the instruction. These are the two options. Either the proceeding, you can allow the petitioner to consider this bid. One is option. Second option, wait, short affidavit direction, file the affidavit. I will fix a specific date
Absolutely.
for a specifically fixed hearing. The matter can be heard.
May I take instruction? and
Take
come at
instruction.
2 p.m. my lord?
Come at 2:30.
Lord,
I only have a right to participate, nothing else. I only want to.
That's a two. If right to participate, if it is
Yes.
allowed,
Yes.
then you also intimate your authority what will the effect of if the writ petition is dismissed and if is allowed in the work order.
And not only one thing, suppose I am not allowed today and if I succeed in the other writ
That's why.
petition, then
If-
what? You have to have a balance.
If it is not allowed today,
Yes.
no, I appreciate.
and both way.
Yes. May I take instructions? And
Huh? 2:30, yes. But I'll come back at 2:30.
Okay, pass over at 2:30. Next.
May I please, Lord? A matter relating to tender amount, my lord. Out of 75 lakhs, my lord, pursuant to the Honorable Court's direction of the coordinated bench of your lordship, my lord, rupees 36 lakhs has been paid.
36 lakhs?
Has been paid.
Correct.
And remaining 39 lakhs rupees, my lord, report has been filed, my lord. I have received the copy of the report. Mr. HON'BLE Sen is appearing in this matter. I have informed him. He was here, my lord. Like, your lordship kindly sees that order dated 4th of September 2025 at first.
This is the report, my lord. I have already served the report.
Yes, this is my exception.
Exhort the DNI দিয়েছেন?
This is my exception. Lordship,
Then what has happened?
Then, my lord, report has been filed.
Correct.
My lord, in this report, my lord, your lordship kindly sees.
What is the urgency? You have 3 days, you have charted, you have mentioned the matter before this court. Where is the urgency?
Urgency is, my lord, rupees 39 lakhs is due, my lord. And my lord, my wife is.
Just a minute.
That, lordship kindly sees, my lord. The wife of the petitioner is a bedridden, my lord. It is suffering from a cruel disease, cancer, my lord.
The court has to decide this on merit.
On merit.
Because there is an objection in the report. You
Yes.
file the exception. The court has to use the mind. It is not an interim order is to be passed. You have mentioned in the last date.
Kindly fix
The
a date.
petitioner has mentioned the matter for urgent hearing.
But kindly fix
when
the
the
date.
matter is taken up for hearing, this court find that the matter is to be heard on merit. As the respondents have filed the report, and the petitioner is agreed with the said report and filed the exception to the said report. Let the matter appear on give the date.
Fix a date.
কি করছি দাদা আপনার
করছো তোমরা
Lord, kindly fix it 2 p.m.
কপি দিন
ডেটটা দেন
কি দিয়েছি ম্যাটার আপনার নেক্সট কপি দিন নাম্বারটা নেই
13 February पक्का
এটা না এটা 8
13 February at 2 p.m. as a specially fixed matter.
2 p.m. my lord.
Yes,
Yes,
as a specially fixed matter.
yes, thank you. Lordship, develop.
Next.
13
February.
কপি ডেট
13
February, specially fixed matter.
well leave was given
Affairs to do.
I will not give you trouble today
Yes, sir.
leave was given I will not give you much trouble today
Yes.
May it please your lordship, my lord. There is an order which has been passed, my lord, by the SDO, which is at page 69. I'll say, my lord, this has been passed in sheer violation.
leave
of the
aside
order.
leave aside everything but I am suggesting let the meeting be commenced from 1 p.m. up to 5 p.m.
Okay, sir.
and crowd should be reduced to 5,000
5,000. It's a 1,01,000 square
no
feet.
no তুই তো 15,000 টা দিয়েছিস
15, yes.
5,000 যা লোক ঢুকে গেছে আর তো আসবে না
5,000.
5,000 আচ্ছা 7,000 microphone 50
Very good.
Thank you.
But you also you tell your volunteers do not create any chaos and traffic
that order,
traffic.
Order will record.
Yes,
That order
yes.
will record. That order.
I'm grateful to your lordship and grateful to
Grateful to the
for the suggestion, my lord.
No, at the suggestions, not with the you don't call me.
Matter is listed as urgent matter in the supplementary list. The petitioner has filed the present writ application challenging the order passed by the sub-divisional officer Kagdip, South 24 Pargana, dated 23rd December 2025.
বলেছিস তারপর তো আমার কিছু করার নেই কাল
Passed by this court. Compliance of the order passed by this court on 23rd December 2025. The petition, in the said order, the sub-divisional officer has refused to grant permission to the petitioner for holding public meeting. When the matter is called, Learned Senior Advocate Mr. Kalyan Bandyopadhyay, appearing for the state, in its usual fairness, suggested before this court that the petitioner may be allowed to conduct the meeting from 1 p.m.
But from 1 to 5, my lord.
1 p.m. to 5 p.m. at Sagar, Rudranagar, Chaurangi, situated at Mauza Radhan, Rudranagar, Dag number, this one, Dag number 4277, Ketan number 772, with the gathering of 7,000 people.
7,000 আমাকেও তো কিছু রেসপন্স আমার
The leader of the opposition will
try
be
to understand my pressure
10,000 we have prayed for, my lord, keeps us
try
restricted
to
to, my lord,
understand
8,000.
my pressure also this is absolutely I have taken the decision try to understand my pressure
No, very good.
7,000 people. With
Approximately, my lord.
approximately 7,000 people.
approximately বলে আবার 8,000 করে বলবেন না যে 7,000 এর approximately
Approximately 7,000 people. Police. with how many with this speaker and
50 microphones and 8 speakers, my lord.
with the 50 micros
Microphones and 5 speakers.
5 speakers.
এবার স্পিকার কি হবে ওর গলাতেই হয়ে যাবে সব
Four speakers.
4 speakers leader of opposition voice
No, it's a large area, my lord. 1 lakh square feet.
The writ petition is disposed of by directing the authorities to allow the petitioner to conduct the public meeting.
Yes, my lord. It's a
To
public
conduct the
meeting.
public meeting on 24/12/2025 from 1 p.m. to 5 p.m. at the above mentioned address with the gathering of approximate 7,000 people with so microphone and speakers. Okay. The petition is directed that while conducting the meeting to maintain the law and order and shall not violate any law and order in the said place. Full stop. The state authority is also directed to keep vigilance of the meeting of the petition so that the law and order situation cannot be
Extremely
violated.
My lord, may kindly quash, my lord, the impugned order.
As
no be kept in abeyance not set aside.
Abeyance, it's been
No, no,
finally
my lord,
disposed of.
kindly
as the learned senior advocate has given the suggestion, and on the suggestion of the learned senior advocate, this court has allowed the writ application. Accordingly, the order passed by the sub-divisional officer will not give an effect to.
No, that's your lordship's order. It prevails over his order.
Will not give any effect.
And your lordship has not gone into the merit of the matter.
It is further made clear that this court has not gone into the merit
of
the matter. Allegation made therein deemed to have been denied.
Brilliant.
My lord, may I file the affidavit?
Affidavit service is kept with the record. Thank you, sir. Thank you.
Now, this is only for you. I cannot keep you unhappy.
Not happy.
No.
Not my unhappy.
Your smile is very attractive to me.
Thank you.
I am really, I have fallen in love with your smile.
And you know, when I was that side, I loved all the seniors and all the advocates of the Calcutta bar.
Yes.
Grateful to your lordship. Extremely grateful.
Deeply.
And extremely sorry, my lord, from all of us, my lord, save and accept the esteemed senior, my lord, for constantly coming back and troubling your lordship.
Now that's why I request Mr. Bandopadhyay, please see to that a guidance.
Yes.
Can be fixed.
I am
Every time the matter cannot come to the
happy Merry Christmas.
Thank you.
Happy New Year.
Same to you.
You will be here or Port Blair?
Port Blair.
I am supposed to go, but I may not go. I have a
When?
Port Blair. Maybe I on 26, 27. I have a meeting there, and also again on 3rd. 3rd, I may be there.
I term it as journey to heaven. Whenever I get the opportunity to travel
Now
to
if it
Andaman.
is there, then the New Year program in the Andaman.
Grateful to your lordship.
Thank you.
9, my lord, I appear for the petition. My lord, this is a matter, my lord, lordship, my lord, is knowing, my lord, of this kind of matters, my lord, where, my lord, the bank has, my lord, completely frozen my account. My lord, on account of, my lord, certain amounts, kindly turns to, my lord, these kindly sees, my lord, paragraph 5, my lord, I have tabulated the amounts, my lord, my client runs, my lord, restaurants, and my lord, my payments are made through my lord, the unified payment interface, my lord. As lordship knows, my lord, people come, my lord, walk-in customers.
Paragraph 5.
5, my lord, I have tabulated, my lord, the amounts. Kindly sees, my lord. Paragraph 5, my lord, starts at page 7, continues to page 8. My lord, these are, my lord, the emails that I have got from the bank. Kindly sees the amount, 2,157, 1,058. My lord, these are the payments for the, my lord, food bills. Now, my lord, total amount comes to 8,139. Which is, my lord, also mentioned in the paragraph 5. Now, my lord, these emails, lordship would find at page 49 onwards of my writ petition.
Okay, then.
Now, my lord, after that, my lord, the bank sends, my lord, another email to me, my lord, at page 53 of the writ petition. Kindly sees. My lord, they, my lord, start with the statement that they are the custodian of public money and under obligation to monitor transactions. Then they say, my lord, in the second paragraph, bank can restrict, stop operations of account of their customer as a prudent banker. My lord, then in the next paragraph, third paragraph thereof, my lord, they say that we have observed that transactions are not matching with the declared income turnover provided at the time of account opening. Hence, the account has been blocked for debit. Now, my lord, then my lord,
Report, my lord, kindly.
Yes.
my lord, I have, my lord,
Is the bank is the agent of
A-
income tax?
All the bank accounts are out of West Bengal, my lord.
Out of West
bank accounts are, my lord, in the New Market branch of the HDFC Bank.
My lord, kindly see my lord report, my lord.
My lord, the complaints may have generated. Yes. Lord, may I have a copy of that?
Kindly come to second.
Just a minute.
My lord.
My lord, the accounts has been frozen by the Ministry of Home Affairs, India.
Just a minute.
My lord.
Judgment করো দেখা যাচ্ছে আপনি যদি দেখতে চান আগে জিনিসটা দেখি
On receipt of the complaint regarding fraudulent transaction associated with the above mentioned account from different police station of different district outside the West Bengal. What is the meaning of the, kindly see the second paragraph, second page, the first paragraph. What is the meaning on that?
This police station didn't.
Yes. No. Maintained a new market branch were frozen by the Central Ministry of Home Affairs Department. Full stop. No problem. Then, on receipt of the complaint regarding fraudulent transaction associated with the above mentioned bank accounts from different police station of the different states outside the West Bengal were frozen by the MHA.
Yes. My lord.
Which is not under the jurisdiction of the Park Street.
My lord.
आगे पाठिए
My lord, kindly come to annexary A, my lord. Kindly go through the same, my lord. Accounts, regarding the accounts, my lord, which has been forced by the different police station out of the West Bengal, my lord, from different states, my lord.
Case is not with regard different police station. This case is regarding the account of the petitioner.
Yes, my lord.
So this petition is not asking for defreezing the account of the other persons.
My lord, West Bengal police has not frozen.
Ah.
My lord, this has been frozen by the other police station of other state.
Show me the order under section 106 and 107 of the BNS says that the police authorities obtain an order from the criminal court for freezing of the account of the petitioner. Show me.
It will, my lord, submitted by the, my lord, reserve.
So, yes, which order?
India, my lord, not
Show,
my lord,
show the order,
my
show
lord.
the order.
My lord, that order I have no, my lord, kindly keep it on, my lord, other day so that I can produce the same.
What order you produce?
My lord, regarding 105 and 6, my lord, of BNSS.
Yes, is there any order?
If there is no, my lord.
Again,
My lord, West Bengal police have not frozen the, my lord, account.
Concern, the police is not the concern here.
My
The
lord.
concern is with regard to the bank account of the petitioner, which is maintaining in the branch situated at the Park Circus.
New Market branch.
New Market branch.
My lord.
Correct. New Market branch, Calcutta is within the jurisdiction of this court. Petitioner is residing here. Petitioner is having the account of the in your bank. So whether it has been seized by the American police or it is seized by the Australian police or it has been seized by the Delhi police or it is seized by the Madhya Pradesh police. Nothing to do with this. The court has to see where the cause of action arose. You have seized, you have freezed.
No, my lord, I have not. I am appearing for the
So
state.
can I record you are
State,
not
my lord.
freezed? Can I record that the bank has not freezed the account?
Well, I understand.
For the bank, my lord, I am for the state, my lord.
So why you are so hurrying? Why you are so agitating that? If you are not for the bank,
I am not for.
why you are for the why you are agitating?
My lord, I have submitted my report, my lord, from state, my lord.
My lord, the bank has been served, my lord. We have, my lord, this is the affidavit service. আমাদের কপিটা, সার্ভিসের কপিটা। আরেকজন কোথায়? My lord, we have served, my lord, through, my lord, physical mode also, my lord, we have hand delivered the same upon the bank. Kindly seize, my lord, এই যে order চিঠিটা দেখো। এই যে, my lord, the page 6 of the affidavit of service, my lord. It was served upon the bank itself, my lord, by hand delivery. My lord, today, my lord, I am not asking for, my lord, just my lord, the lien amount may be kept, my lord, and hold, my lord, and my lord, let my operate my account. My lord, the account position, lordship will find. Now, which paragraph dekha? Yes. My lord, my ground, my lord, page para 24. My lord, I have a balance of 13,58,941 in my account lying. My lord, the allegation is regarding 8,139. My lord, I am respectfully submitting, my lord, that amount may be kept on hold, my lord, and the rest of the bank account may be allowed to be opened.
Order passed by this court.
Yes, my lord, I think. Manush Janata. Yes, yes, my lord, I am. My lord, lordship had, my lord, kindly.
Yes. The petitioner has filed the present writ application praying for a direction upon the respondent number.
My lord, the bank is respondent number 9.
Respondent number 9.
9 and 10.
Respondent number 9
is
and 10. To
branch
allow the
manager.
petitioner to respondent number 9 to defreeze the account of the petitioner and to allow the petitioner to operate the bank account. The petitioner submits that the petitioner is having which current account of
My lord, all current accounts, my lord.
petitioner is having altogether 4 current accounts.
5, my lord. 5.
You are mentioning
5. I have mentioned, my lord. Kindly seize, my lord, the paragraph 4 of my application, my lord. I have mentioned the 5 account numbers at page 7.
Is altogether having 5 current accounts being number 5020083652467, comma 502000645317 comma 502000839 4 times 3 4 comma 5020074970282 and 5020095379412. The counsel for the petition submit that on 9/9/2025 the bank has hold or freezed.
My lord, put on hold. And my
Bank
lord,
has,
thereafter,
bank-
my lord, debit transaction has been put on hold. All-
Bank has put on hold with respect to account number 5020007497028 for an amount of rupees 2157. On 13 September 2025, the bank has hold the account of the petition, account number of the petition being number, has hold the account number 5020074970282 for an amount of 1058. On 14 November 2025, the account number 5020008365247 is kept on hold for an amount of 2209. And on 30 November 2025, the bank has put on hold the account number 502000749700282 for an amount rupees 2,715. These are the four.
My lord, the four, and my lord, kindly sees, my lord, the next page, my lord, this account 267.
Four. And again,
My lord, I have a printout of the, my lord, dormant accounts, my lord. These have been rendered dormant and put on.
and again, on which date?
My lord, all with the same bank, my lord.
And again, the bank has put on hold the account number 502000836524667. 67. Counsel for the petition submitted. Subsequently, the bank is not allowing the petitioner to operate the said bank accounts. He submit that all the accounts of the petitioner is a current bank account, due to which the petitioner is facing difficulties to run his business.
My lord.
Run his business. He further submit that the petitioner has made several representations to the bank, but till date, the bank has not defreezed the account of the petitioner, nor the bank is allowing the petitioner to operate the bank account. The petitioner has served the notice upon all the respondent authorities. In spite of service of notice, none appears on behalf of the bank. Affidavit of service filed by the petitioner be kept with the record. The state has filed the report and submits that the transaction made with the petitioner bank by the other banks which are situated outside the jurisdiction of this court, and as such this court is not having the jurisdiction to entertain the writ application. Counsel for the petitioner submit that the total disputed amount on the basis of which the bank has hold the account of the petitioner, current bank account of the petitioner, and not allowing the petitioner to operate the bank account is only rupees 8,139.
Grateful, my lord.
39. Due to which the petitioner is not in a position to operate the bank account for the further amount which belongs to the petitioner's business. Full stop. At the learned counsel, full stop. This court specifically inquired from the state respondent whether the bank has obtained or whether the investigating agency has obtained any order from the concerned court for freezing the account of the petitioner, the learned advocate appearing for the state submit that the bank account has been freezed on the instruction of the other police station which are not within the jurisdiction of the state of West Bengal, and as such is not in a position to give any reply to the same. Full stop. In spite of service of notice, none appears on behalf of the bank. No document has been placed before this court on what circumstances the account of the petitioner has been at first the account of the petitioner was kept on hold, and subsequently it has been freezed by not allowing the petitioner to operate the bank account. Full stop. In the case of census, I will give that. In the case of census, the division bench of the Honorable High Court has held that division bench of the Bombay High Court, relying upon the order passed by the Kerala High Court, has passed the following, held as follows. You are having that?
My lord. Bombay High Court or Kerala High Court. My lord, I just
give the Bombay High Court, that will suffice.
Why are you so slow? Yes. Yes. Perhaps my lordship is referring to this.
In the case of Karthik Yogeshwar Chatur versus Union of India and others, reported in 2025 SEC Online Bombay 4778.
Paragraph 15 and 16 perhaps.
Relying upon the judgment passed by the Kerala High Court has held that Paragraph 9(2). Paragraph 9(2). Paragraph 13. 1. Police. Considering the above, this court find that this court find that to the bank in spite of service of notice not indicated. Considering the above, this court find that the disputed amount is only rupees 8,139. Accordingly, the bank is directed to allow the petitioner to operate the bank accounts of the petitioner by keeping aside an amount of rupees 8,139 as mentioned above till the final decision taken by the authority on whose instruction the bank has hold the amount in the said amount. Full stop.
I am grateful to your lordship. My lord, lordship is fixing any time frame for the bank to act immediate. Very good. I am grateful.
Yeah. तो है उसे चेंज होगा तो अच्छा है, चेंज नहीं हुआ.
Yes.
Article number 10. My petition, Milord, have served. Milord, this is against removal of my name from the register of registered medical practitioners maintained by the West Bengal Medical Council. My lord need not look at the records. I just give Milord what I was and Milord why this happened. Milord, I was a medical teacher. Milord, as they call me. Milord, as the law also calls me. Milord, I was an assistant professor in IPGMER, the PG hospital. Then, Milord, I was promoted as a professor in Milord, a district Milord medical hospital, where Milord, I was again promoted to the post of head of department anatomy. Now, because of Milord, my experience, Milord, I was also Milord made a member of an inspection committee who Milord inspects the colleges. Milord furnishes report to the appropriate authority for the authority to take a decision as regards upgradation or whatever. Now, Milord, there was an allegation from sources. Milord, CBI called it sources. From sources that Milord, I asked for bribe for Milord giving a favorable report. And Milord, I was caught. Milord, I was kept Milord put into judicial custody. Now I have been enlarged on bail.
Any amount was
Yes, 10 lakh Milord was Milord the amount which Milord according Milord to the Caesar list was Milord seized from me.
24 lakhs.
Now Milord, why Milord I was in judicial custody? Milord, I was issued a notice. The notice reached me Milord after I was Milord enlarged on bail. It's a one-page notice at Milord page 40. Page 39.
Page
39, which is Milord the subject matter of challenge. Page 39. This is Milord subject matter of challenge here. Milord, this is coming from the registrar of West Bengal Medical Council. On Milord 2nd June, I was enlarged on bail Milord in July. It has been observed from press clippings that Central Bureau of Investigation has initiated an inquiry against you at the behest of National Medical Commission, may not be Milord correct, alleging improper financial transaction, and you have been detained by central agency in this connection. Considering the grave kind of allegation leveled against you, your name is hereby removed from the register of the register. Now, Milord, there is an act. The section 25 of the Bengal Medical Act is the only statutory provision, Milord, subject to limitation.
That no procedure has not been followed.
It's not only procedure, Milord, section 25, if my lord kindly takes the trouble to have a look at. Milord,
25.
25. It contemplates, Milord, two eventualities where, Milord, my name can be struck off the roll. One is if I am convicted, not Milord in course of criminal investigation.
Clause 25.
25A Roman 1.
Yes.
The council may direct that the name of any registered practitioner who has been sentenced by any court for any non-bailable offence and such sentence not having been subsequently
Where
referred
from you are reading?
from the Act, my lord.
25A.
25A.
Small a, my lord, not capital A.
25 small a.
Small.
25, my lord. I'm sorry, my lord. I should have indicated
On the
that.
upper of the 25 capital A.
My lord has kindly got it.
Name of any registered practitioner.
Yes.
The council may direct.
Yes, that the name of any registered practitioner who has been sentenced by any court for any non-bailable offence, such sentence not having been subsequently reversed or quashed, and such person's disqualification on account of such sentence not having been removed by an order which the local government are hereby empowered to make if they think fit in this behalf, or from the whom the council, after due inquiry in the same manner as provided in clause B of section 17, have found guilty. So, these are the two eventualities when my name can be removed from the register of registered practitioners. Small one, Roman 1 does not apply because here the investigation is pending, the matter is still going on. Now, kindly take section 17, the second eventuality. Milord 17 says how someone's name is to be incorporated in the register of medical practitioners. Then kindly turn over the page, kindly come to the next page. There is a proviso to section 17 which says, provided that the council may refuse to permit the registration of a member, again the same thing, who has been sentenced by any court. And then B, who the council after due inquiry, at which an opportunity has been given to him to be heard in his defense and to appear either in person or by counsel, vakil, pleader, attorney, which may in the discretion of the president be held in camera, have found guilty by a majority of 2/3 of the members present and voting. Nothing has happened. I am not on the principle of natural justice. I know natural justice is not an unruly horse, not a larking landmine. I am not on that. Here there is a provision. They don't have jurisdiction to remove my name unless I am held guilty and convicted by a criminal court of law. So these are.
I'm for the medical council. My learned friend said that 10 lakhs was seized. That is not the fact. Page 36 minus 24 lakhs 48,920 was seized.
Wait, I stand corrected.
Where page?
Page 36.
36.
My lord. Continuing portion of the seizure, my lord. On the bottom, my lord.
My lord, red-handed.
Right-handed, my lord. During the
playing procedure.
During the search, total amount of rupees 24 lakh 46,000.
That's not my premise.
No.
10 lakh was seized, from Borobazar, which is the allegation. I can show it from the records.
Allegation of taking 10 lakhs.
Correct.
24 lakhs was seized, my lord.
Yes,
that was from my residence.
Teaser memo reflects that. How much amount?
My lord, kindly take the arrest memo, page 29. It's 10 lakh. The allegation is that.
Allegation of 10 lakh?
Yes. And 24 lakh is from my residence. I have my money there. Kindly take page 32. My lord, need not look at anything else. I need not trouble your lordship. Kindly turn to page 32, last two lines. This is checklist, which my lord is now looking.
10 lakhs. Yes.
My lord, kindly see the bail order, page 43, last portion. The appellant accused shall not come in contact, intimate the witness of the present case, especially the witness pertaining to his department, nor shall tamper with evidence of the present case with the view to prejudice. His department, all are the doctors, my lord. He was also a respectable professor of the Mehusabad Medical College, of head of the department of the anatomy. The allegation against him, and he was in custody. When he was in custody, the order was issued for the removal, and my lord kindly got section 26. There is a provision of the appeal.
Hurry.
An appeal shall lie to the local government from every decision of the council under section 17 or section 25.
Correct. But I say this is not a decision under section 25, so no appeal lies.
There is alternate remedy, my lord. He, without saturation of that, my lord, he came before this honorable court, and he have no.
That I will come to you. That I will
The
come to
charge sheet
you.
was not been passed.
Kindly come to the section 25.
My lord.
I.
My lord.
So it's not been sentenced.
No, second, whom the council after due inquiry in the same manner as provided by in
Section
clause
17. Now,
yes.
Clause B section. Kindly come to the clause B of section 17.
My lord.
Whom the after due inquiry, at which an opportunity has been given to him to be heard in his defense and to appear either in person or counsel, vakil, pleader, which may be discretion of the president. He held the in camera, have found guilty.
My lord, at the time he was in custody. My lord, kindly see the date.
Correct. So that's why custody, so you will not give an opportunity.
How he will appear, my lord, from custody? He was in the CBI custody.
So what is the urgency to, if a person is already in custody, what is the urgency to remove when he was in custody?
One professor doing, my lord, this kind of, what will be the fate of the medical education of the country, my lord? I do not know, my lord. One professor is giving the inspection report for favoring of 10 lakhs, my lord. My lord, kindly consider it, my lord. We are in the hands of the doctors. If that type of doctors come from the medical college, that for favoritism of 10 lakhs rupees, my lord, it is very unfortunate, my lord, for from this accept of the petitioner, my lord.
Have you heard the case of the Delhi? The DGP has had the 3 crore rupees. Just you heard the news. The Lieutenant Colonel is having the 200 half crore rupees.
That have
And
to
this
check.
court is not passing any order to allow to operate. Be a member. This court is only telling, testing whether the impugn order justifies section 25 or 17. You satisfy this, nothing else. You will not satisfy, I will caution it with the given a liberty to take appropriate steps in accordance with law. That's all, nothing else.
But in the meantime, we cannot restore him.
Sir, a person, you had a criminal practice, or you have a service rule practice. Have a criminal practice or service rule practice. What is, once a person is arrested and was custody for 48 hours, a deemed suspension. One thing. Second thing, government, if you want to punish the person on the basis of the criminal proceeding, you have to initiate a regular departmental proceeding. First, you have to initiate the preliminary inquiry, then you start the regular disciplinary proceeding, giving an opportunity, punish it. But you are covering under the West Bengal Council Act. So you have to follow the 25 and 17. 17 says B, because 25 says 17B. 17B says the opportunity. You are telling he is in custody. So what is the necessity of the urgency of the passing of the order? That is the only thing. So I am setting aside, if you want to submit anything, you can submit it.
Well, if we restore his name, he will mix with the.
What restoration?
I do not restore his name in the register.
Whether he has been made,
whether
he has been placed under suspension.
No.
Then
he is under suspension. He was in custody in the CBI for 45 days.
Where is the order?
He did not annex it.
You are appearing.
I am not appearing on the of the state. He is under the state. He is the professor of the medical
My
university.
learned friend is Millard.
I am the medical council, my lord.
Confusing two things together.
Correct.
Millard, one is Millard member of Millard the West Bengal Medical Council as a registered medical practitioner. The other one is Millard by employment. Millard, if my name is restored today and if this order is set aside, I don't get my job back.
Nothing.
But he can got the opportunity to mix his fellow friends. What was restrained by the court.
Sir, that is with that the criminal court has passed an order.
My lord.
Condition. I will record that.
Yes.
I will record your submission.
My lord.
Only I will set aside this order because of the violation of this provision. You not comply with the provision. I am setting up, but giving the this not prevent you to take appropriate.
That is always there.
My lord.
Always there.
Petitioner has challenged the impugn order. Where is the order?
Millard 39.
Impugn order dated. Impugn communication order now. Communication dated 2nd June 2025, wherein the registrar West Bengal Medical Council has informed the petitioner that inverted comma, considering the grave kind of allegation labeled against the petitioner, the name of the petitioner removed from the register of the registered medical practitioner being maintained by the council from the date of issue of this order, inward comma close. Full stop. Counsel for the petitioners, Mr. Banerjee, an advocate appearing for the petitioner, submit that the impugn order, the impugn communication is in violation of section. It's section or regulation? What is action?
Sections, my lord.
Section.
Sections.
Violation of the section 25
And 17 of Bengal Medical.
5 as well as section 17 as 25 and 17 of the
Bengal Medical.
Of the Bengal Medical Act 1914.
Yes.
14. He submits that full stop. He submits that as the impugn communication is violation of the provisions of law, and as such the same is liable to be set aside. Per contra, an advocate appearing for the West Bengal Medical Council. West Bengal Medical Council submits that the allegation against the petitioner is grave in nature. He submits that 10 lakh rupees have been seized from the possession of the
24 lakhs or something was seized
from the seized from the possession of the accused and subsequent the petitioner, and subsequently when the investigating agency has searched the house of the petitioner, further amount of 24 lakh.
24 was 46,920.
Amount of rupees 24 lakh.
46,920.
46 lakh 920 was recovered from the house of the petitioner. Full stop. He further submits that the CBI has arrested the petitioner for the offence under section 61 within bracket 2 of BNS, read with section 7, 8, 9, 10 and 12 of the Prevention of Corruption Act 1988, and the learned special judge under POC Act, Ross Avenue Court, New Delhi, has, while granting the bail to the petitioner, has imposed several conditions so that the petitioner cannot mingle with the witnesses of the department and to hamper the investigation of the CBI case. Full stop. Counsel for the respondent submits that the impugn order is passed taking into consideration of the grave allegation against the petitioner. Anything further?
No, my lord.
What they
I'll kindly record this is appealable order.
Huh?
I might record my submission that this is appealable order.
He further submit that under the Act, under section
26.
Under section 26 of the Act, the impugn order dated 2nd June 2026 is an appealable order, but the petitioner, instead of filing the appeal, has preferred the writ application, and the writ application is not maintained. Had the learned counsel for the respective parties peruse the materials from the court. Section 25 A लिखे ना dot सब लो, then I and I set out करना, ठीक है, page 2 well 25 A को dot I फिर उसके बाद section 17 A dot B set out. This could find that in the communication, in the impugn communication dated 6th June 2025, the authorities have alleged that a grave kind of allegation has been leveled against the petitioner. Accordingly, the name of the petitioner has removed from the register of registered medical practitioner being maintained by the council. Full stop. The provisions for removal of the name of the registered practitioner is provided under section 25 as mentioned above. As per section 25 II, the after due inquiry in the same manner as provided in clause small within bracket small b of section 17, if the authority found guilty by majority of the two-thirds of the members present, the present and violating at the meeting, voting of the present and voting of the meeting of infamous conduct in professional respect, the authority can remove the registered name of the practitioner from the registered from the register of the registered medical practitioner. Full stop. In the present case, this court finds that simply on the basis of arrest of the petitioner in the criminal case initiated by the CBI, the West Bengal Medical Council has removed the name of the petitioner without following the provisions as provided under section 17 within bracket B of the Act. Full stop. This could find that the authorities have passed the impugn order without following the due process of law, as provided under section 17 within bracket B of the Act. Thus the submission made by the petitioner that the order passed by the impugn order is appealable order is no leg to stand, as the authorities
submission made by the respondent.
Respondent is no leg to stand, as the authorities has not followed the due process of law. Thus, the writ petition is maintainable. Considering the above, the impugned communication dated 6th June 2025, appearing at page 39, being annexed P3, is set aside and quashed.
Grateful.
Full stop. However, it is made clear that this order will not prevent the respondent authorities to take appropriate steps against the petitioner in accordance with WPS disposed of.
The affidavit of service made by learned friend is subject. Grateful to your lordship. Grateful.
Next.
Lordship, I'm appearing on behalf of the writ petitioners and I'm led by my senior Mr. Jishnu Shaha. Upon his mentioning, your Lordship was pleased to grant liberty to us to move the matter before the vacation bench, your Lordship.
By an order dated 23rd December 2025, this court has granted leave the petitioner to mention the matter before the vacation bench for early hearing. But the learned counsel for the petitioner submit that the order is to be modified by allowing the petitioner to
Lordship, 29th December.
Do what? What you want?
Lordship, I am praying for stay on the notice dated 15th December, your Lordship.
What
To move the matter.
Move the matter before the
vacation bench on 29th December, your Lordship.
29th of January 2025 and 29th of December 2025. Accordingly, the order dated 23rd December 2025 is modified to the extent that modified by giving liberty to the petitioner to move the matter before the vacation bench on 29th of December 2025.
Grateful, your Lordship.
Next. Call then let.
My lord, item numbers 11 and 12, my lord, I appear for the writ petitioners, my lord. I'm led by my lord Mr. Jishnu Chaudhary in these matters, my lord. I'm only praying, my lord, if the matters can stand over, my lord, after this vacation, my lord.
Well, as I beg to appear for the bank, the sole respondent in this matter.
My senior.
Yes, well, two submissions I wish to make. One is that the reply, we want to physically tender. So, my colleague is there in the court with the reply. Your lordship may take the reply. The second request is that I have come to understand that this matter was mentioned yesterday to be listed today for arguments. So, the understanding was that it will be argued today. And today my friend is now asking for an adjournment. So your lordships perhaps were a little upset that a lot of matters were being mentioned for hearing today and we have a case of an adjournment today. But that said, there is no interim order in this matter. So your lordship may fix a date in January. My lords, we will address your lordships.
You file the reply?
Yes, sir, I'm finding the reply. My lord, the affidavit of service. Not required.
Affidavit of service, affidavit in opposition, and affidavit in reply filed by the parties be kept with the record. Learned counsel for the petitioner prays for fixing the matter after the vacation for final hearing. In view of the submission made by the counsel for the petition, let the matter appear. So it is ready for hearing.
Yes, yes.
Yes, my lord.
Yes, my
Give the
lord.
date for hearing. तेरह
My lord keeps it in January.
तेरह कहाँ से होगा? 13 तो लास्ट डेट दे दिया.
15th.
कब है?
Item.
16th February at 2 p.m. a specially fixed matter.
Yes, your lordship.
Yes,
Deeply
Mr.
obliged, my lord.
Deeply obliged.
15th of February, my lords. Your lordship says 16th of February.
16th February
Yes, yes, my lords. I'm grateful.
at 2 p.m. as a
Deep-
specially fixed matter.
Yes, deeply obliged.
Deeply obliged, my lord. Grateful.
Grateful.
Next.
Petitioner.
Yes. Item number 12. 11, 12. 11, 12 same.
11, 12, I think is same matter.
Yes, my lords. 11 and 12, my lords, are same matters. Both of them can be on 16th of February.
Same order.
Next. 13.
My lord, I am appearing for the writ petitioner, my lord. Last
minor direction, my lord, I am filing the.
my lord, a copy of the report may be given to me.
Yes, you have a report.
Yes, my lord, I have a.
Give the copy.
At a copy of it. It would appear from the report, my lord, the district-wide psychiatrists were appointed, but the mental review board had not yet been constituted.
Each mental review board in respect of the district has been issued by the department with information to all concerned. On direction has been given to the respective district magistrate to nominate their representative well in advance to attend the mental review board. Yes.
So one step has been taken pursuant to my lord's guidance, my lord. Further needs to be taken, my lord. My lord, this is the order dated 30th October 2025.
Correct.
And other, my lord, other designated are to be appointed. My lord, kindly come to the order, my lord. In continuation of the office memo number such and such in respect of the continuation of mental health review board in various districts, please find enclosed here the name of nominated psychiatrist and medical officer from the various government hospitals for each district. Psychiatrist and medical officers so nominated hereby in case of absence or leave or to be out of station due to any exigencies on the date of meeting of mental health review board. Arrangement of the suitable substitution to attend said meetings will be made by the concerned COMH of the district. Concerned district magistrate or his or representative are the constituent members of the respective RBS. The representative of the concerned district magistrate of the respective mental health review board in this respect shall be notified well in advance by the district magistrates concerned to attend the meetings of the mental health review board. That means, my lord, at present, my lord, this is the approval of the chairperson of the mental health authority, my lord. At present, my lord, mental health review board district wise has not yet been constituted.
So you tell me, leave aside all this. Which district you belongs?
I am belonging the Kolkata district, my lord.
Kolkata district.
Yes.
So I am directing an order, passing an order, I am passing an order directing the district magistrate of the Kolkata, what is
Kolkata
that?
district, I do not think that there is any district magistrate, my lord.
District magistrate not there. Who is the district? Yeah, district magistrate.
Kolkata, my lord.
The Kolkata, who will be, because here the district magistrate has given. So if the district magistrate is not there, so how
No,
this
my
can
lord
be?
will direct the chairman to ensure functioning of this Kolkata.
Chairman is telling that unless the name has not been provided. That is the problem.
My lord, in that even, my lord, the Institute of Psychiatry is a mental hospital of.
This order said the concerned district magistrate or representatives are constituted a
Right.
member of MHRBs. The representative of concerned DM of the respective MHRB in respect of the
Milord,
notified.
the mental
DM has to notify.
What if that district does not have a district magistrate? That is true, Milord.
And Milord, furthermore, the DM has to notify the constitution of the mental.
That's I'm telling. That's why the court is telling if there is no district magistrate of with regard to the Calcutta region. So what would be the effect of this order with regard to your case? You are causing your case.
Yes.
You
Milord,
file the writ application with causing
my
your.
lord, the purpose of this writ petition is to appointment for the appointment of the nominated represented under section 14 of the Mental Health Care Act 2017.
Correct.
As because the mental health, that is, my lord, the Mental Health Act. My lord, the Mental Health Act has already been repealed.
There has to be something like, Milord, the in corporation areas, it has to be the commissioner or something like that.
List of the nominated psychiatrists with the district mental review. Kindly come to the page number 3 of this report.
Page 17. Page 16 and 17, my lord, of the writ petition. Of the writ petition.
No, I am telling this. You go.
Yes.
Who is the psychiatrist in your jurisdiction? Where this patient reside?
Dr. Shomik Pornopol, serial number 28.
Serial number 28.
Yes.
My lord will take note of page 17 of the writ petition. My learned junior has rightly pointed out, my lord.
17.
17. কে হবে রেকমেন্ডেশন বা চেয়ারপারসন কি হবে সেটা বলেছে।
My lord, this is the reason, my lord.
Yes, sir. Just let the court understand what.
Yes.
Page 17 says, my lord, the Chief Judge, City Civil Court will be the chairperson of KMC area and Hooghly area.
Correct.
Yes.
Now it is for the Chief Judge, my lord, to facilitate.
There is a letter of the Chief Judge. Where is that? She's telling that no psychiatrist has been given. Where is that?
Yes, my lord. Next page 18.
18.
Registrar General of the Honorable High Court was addressed. With reference to the above, I am to say that despite the appointment of the chairperson of District Mental Health Review Board for KMC area, the district of Hooghly by the Honorable Court, Calcutta, as per recommendation of the chairpersons of West Bengal Mental Health Authority, my office has not yet received any communication from the government of the West Bengal completion of the constitution of the said board, because
we have worked.
We have appointed psychiatrists, and my lord, the particular administrative authorities are required to appoint it, my lord.
That's what the DM duty of the DM is given, but here DM is not here.
May I come back before Lordship?
The DM is not here, so what can be done?
My lord, in earlier occasion, in the year of 2020, there was also not constituted the board, and this is my personal case, my lord, and where, my lord, this is the order. My lord, here I was appeared as a petitioner in person, and my lord, here this particular Manusi Mojumdar was granted custody in mine.
So what is the prayer in the present writ application?
That is, the mother will take the custody of the child and do all the necessary things for the welfare of the particular. So that is the prayer I have made. Yes, my lord, that is from appear at page 10. That is prayer A. Issue a writ of in nature of mandamus commanding the respondent and each of them to act in accordance with law, and to assign reason as to why the petitioner number 1, that is the mother, natural mother, should not be granted custody of the victim girl in favor of the petitioner number 1.
So who will constitute the committee?
My lord,
as per the act.
As per the act, my lord. My lord,
page 17.
As per the Act, my lord, the section 73 is the constitution of the Mental Health Board. The state authority shall notify, comma, constitute the board to be called Mental Health Review Board for the purpose of this act. I have only single copy, my lord. The requisite number, location, and jurisdiction of the board shall be specified by the state authority
Correct.
in consultation with the state government concerned.
So the chairman is appointed.
Chairman is appointed, but my lord, this has been superseded by the.
Tell me. The chairman is appointed.
Yes.
The Chief Justice Citizen. I don't think she is now the Chief Justice Civil Court.
Yes, he is not.
He is not the.
Not the Chief Justice of.
Whether it is by name or by post.
It is by. It appears from the page 17 that it is by post.
By post,
Appointment of this lady, that Chief Judge, whether it was by name
That is,
or it was post.
That is
his name, then again it will be in trouble.
No.
Where is the order of the appointment of the chairman?
My lord, this appear at page 17, Chief Judge, City Civil Court.
Chief Judge, City Civil Court.
Yes. Whoever the learned person may be.
KMC and Hooghly.
KMC and Hooghly.
Correct. So no chairperson. So now who will constitute the committee? Again, this state has to constitute a committee.
Yes.
Now, the state has also appointed the psychiatrist.
But the other members are required to.
How many members are required as per the committee constitution?
My lord, the composition of board, each board shall consist of district judge or an officer of the state judicial services who is qualified.
That is done.
And my lord, second, the representative of the district collector.
District collector
or district magistrate, or
that's why that is the district collector, district magistrate is not here.
Yes, two members of whom one shall be a psychiatrist, which has been appointed.
Correct.
And other shall be a medical practitioner that has not been appointed, my lord. And my lord, D, two members who shall be person with mental illness or caregiver or person representative organization of the person with mental illness. A person shall be then, my lord, Q. A person shall be disqualified to be appointed. So, my lord, this is only 74, subsection 1. Yes. 8 persons are required to be appointed apart from the psychiatrist.
73.
74. 74, subsection 1 and all other clauses. Apart from 72, subsection 2.
So, here only the
chairperson and psychiatrist were appointed.
Here the chairperson, that is
Chief Judge.
District judge or the officer of state of judicial, that is A is completed.
Yes.
Representative district collector, but here the collector is not here.
Collector.
So what can be done? Or the deputy commissioner of the district.
Deputy commissioner of.
Who is the authority here in the Calcutta?
I have to find out that. I have to come back.
So what I say, so in terms of section 74, the government has already notified the chief judge of KMC
As the chairman.
and the psychiatrist. With regard to the kindly notify the other persons and to file a report.
Absolutely. Absolutely.
And my lord, in the meantime, the custody of the particular child may be given to the mother, and mother will take all the steps from the Institute of Psychiatry, because she needs treatment as well as the other functions, my lord. Although the act has mentioned the under section 14 that nominated representative, because the mental health review, my lord, if that
is a special act.
Yes.
Court cannot override that.
My lord, that has not been constituted.
That's why the court is trying to constitute that you are.
Let it be their interim measure. For the interim measure, otherwise, my lord, this repetition was.
Where is the mental ill child?
My lord, she was residing. That is 22 stroke.
With whom? With whom?
With his mother, with her mother.
So what is the problem now?
Problem is that the particular, because the SIR is going on, my lord, someone is required to file the complete the entire thing on behalf of the particular daughter, because daughter is a major person, my lord.
Correct. So what further you required?
At least, my lord.
See, the mental illness in your custody.
Yes.
Correct.
Yes.
So what further order is required? It is not that the mental illness person is with the other in custody of other person.
Required to perform some official job on behalf of the daughter.
Official job, that condition is to be imposed by the
Many
committee.
things can happen, my lord, under the garb of these things, my lord.
Yes.
Let us wait for the
appropriate times. But if you have any difficulty, you can approach the court.
In terms of the order passed by this court, comma, the state has submitted the report. Report wherein it reveals that state has submitted the report wherein it reveals that the names of psychiatrists and medical officers. No, name of the psychiatrist and medical board is also given. Can you see the report compliance?
My lord.
Only, my lord.
With the names of the nominated
Medical officers, my lord.
Where is the name of the medical officer?
Medical officer has not been given.
Not
No,
given.
it has been given, my lord. Report says so.
কোথায় আছে medical officer এর নাম?
All psychiatrists.
Yes, next page, my lord.
Next page, my lord, will kindly to come to the last page.
Yes. Oneshwan Ghosh.
Yes.
Dr. Oneshwan Ghosh in the present case.
Where it is?
Page, last
Yes,
page.
yes.
Last page of the report.
28, yes. क्या बोला? Has submitted the report reveals that names of nominated psychiatrists and medical officers of each mental review board in respective of districts has been issued by the department. As per section 74 of the Mental Healthcare Act 2017, the composition of board are as follows. 74 quote kori de na. 74 1.
Only one.
74 1. 1 to A to D. A to D.
Deputy Commissioner.
So the state has appointed
Nominated psychiatrist.
Has nominated the district judge or an officer of the state judicial service and the psychiatrist and the medical practitioner. But the state has full stop. In this said order, it is recorded that the concerned district magistrate or his representatives are the constituent of the members of the respective mental health review board. But in Kolkata,
It will be, my lord, may I point out, 74, my lord, B, my lord, will see district collector, representative of the district collector, district magistrate, or deputy commissioner.
Correct.
Deputy commissioner of the corporation has to be. Cannot be.
That commissioner is different. Because what has happened as per the central portfolios, the district magistrate will be the district collector, and in the union territory it is a district commissioner, deputy commissioner.
Yes.
The deputy commissioner. क्या बोला? MHRP, Mental Health Review Boards. But it is informed to the court that with regard to the Kolkata and Ungli is there. Kolkata, you are from Kolkata and?
I'm from Kolkata.
In Kolkata, there is no post of either district magistrate, district collector, or district magistrate, or the deputy commissioner. And as such, the order dated.
My lord, subject to correction, the district magistrate of South Chobbish Pargana can also be directed.
That's why the state can give the decision.
Yes.
How the court can say you act on that. And as such, the order dated 31st of October 2025 is to clarify who would be the competent officer with regard to the Kolkata, and also to appoint in terms of section 74 within bracket D, that is 2 members who shall be persons with mental illness or caregivers or persons representing organizations of persons with mental illness or caregivers or non-governmental organization working in the field of mental health. The principal secretary.
This was the principal secretary. So let the
Principal
direction.
Secretary, Department of Health and Welfare Department, Health and Family Welfare, Government of West Bengal is directed to submit this clarification or to file by clarifying with regard to constitution of the board in terms of section 24 of the Mental Health Care Act 2017 within a period of 3
My lord,
weeks.
my lord.
3 weeks. This is the matter
On my lord, just after vacation.
on 14th of January 2025 under the same heading.
So may we have the privilege of wishing my lord a very happy Christmas, happy New Year in advance, my lord.
Thank
Yes,
you,
your
same.
lordship. Happy Christmas and happy New Year also.
Thank you, same to you. Next.
My lord, 14, my lord, I am for the petitioner, my lord.
My lord,
My lord,
I appear for
I have
RBI.
took a loan, my lord, from earlier
My lord,
occasion,
I'm
one
for the respond number 227.
Potium Finance Limited, my lord. That is rupees 15 lakhs. And my lord, thereafter, my lord, I have applied before the Bandhan Bank, my lord, to switch over that loan from Potium to the Bandhan. And Bandhan, my lord, the sanctioned loan amount, the 24 lakhs. My lord, out of the 24 lakhs, they have agreed to pay directly to the earlier finance, Potium Finance with interest 15 lakhs and 48,000 and odd. My lord, they have directly paid that amount to the Potium Finance Limited. But my lord, the rest of the amount, 8 lakhs and on, they had agreed to pay by 2 checks. The checks was prepared, but ultimately that was not given to me. My lord, what happened? They have charging the more interest on the basis of the 24 lakh sanctioned amount. Even thereafter, my lord, they have charging more EMI, which was, my lord, settled against the 24 lakhs. But actually, they have paid, my lord, the 15 lakhs, 8,000 and odd. My lord, I have raised the various objection to the bank authorities as well as, my lord, thereafter the Reserve Bank authorities. My lord, thereafter, they have agreed, my lord, there was a wrong. So we are adjusting that 8 lakh and odd amount to your principal amount.
What you want?
My lord, now thereafter, my lord, they have sent a notice for a settlement of rupees, my lord, that 12 lakhs. My lord, by giving 2 installment, one is to be paid, my lord, within the 13th of November 2025, and another is to be paid within the 25th of December 2025. That is within, my lord, the next day, my lord. But my lord, during that, they have sent another notice, my lord, under section 13.2. My lord, what I am now praying before your lordship, my lord, I am ready to pay the entire amount. My lord, kindly extend some time, my lord, within the.
When you will pay the amount?
Yes, my lord.
When you will pay the amount? 25 is tomorrow is the last day.
No, my lord. Actually, my lord. Yes. My lord, the 20.
Tomorrow is the last date of paying the second installment.
Yes, my lord. Thereafter, my lord.
You have not paid the first installment.
My lord, I have requested to till January within pay. I shall pay 5 lakhs, and the rest of the amount 7 lakhs I shall pay within the month of March. But my lord, that request was rejected, and ultimately they have sent another notice on 24th of November. My lord, after the settlement amount of on 90.
Pay the settlement amount. What the bank will do?
My lord, only my prayer before your lordship, my lord, kindly allow me to extend some time, my lord.
My lord,
Within
this repetition is at all not maintainable.
How it can be? Who are you?
Not at all maintainable.
You are the borrower.
My lord,
They are the bank.
Yes.
my lord, I am ready to pay the entire amount.
How the reputation is maintainable against the bank? Which bank?
My lord, Bandhan Bank.
Huh?
Bandhan Bank.
Bandhan Bank is private.
Not maintainable. There are
No.
category of judgments, my lord, passed by the Supreme Court. My lord, recently.
Private.
Yes.
There is no direction upon the police and all about the police.
Nothing, my lord.
No. I am not paying anything before the any authorities. My lord, now, my lord, after this notice of 19 November, my lord.
Okay. Just see. Leaving aside the
19
maintainable, if you tell that you will pay the amount by 30th December, I will dispose of herein now.
Yes.
If they are agreed to accept the amount.
I shall pay the entire amount, my lord. Kindly extend. kindly extended some time.
No,
my
my
lord.
lord. Extension
You will
cannot
pay
be
the
granted.
amount by 30th December.
Yes,
My lord,
absolutely,
in
my lord.
course of tomorrow, my
Without
lord,
taking the consent of the bank, I am.
my lord, in course of tomorrow, it is very difficult to pay 12 lakhs.
My lord, we are sticking to our notice, my lord. We will not move from our notice. Yes,
Dismissing the 13 notice has been given, go to the
once,
DRT.
my lord, 13 to yes,
My lord, no, no, my lord,
grateful,
my lord,
it goes out from the writ
my lord,
jurisdiction.
kindly see.
Absolutely.
My lord,
I appreciate, sir. Once 13-2 has been given to you, you're not
My
the
lord, that
OTS,
it-
not OTS, the settlement which was arrived between you, you
Yes,
have not adhered to.
Yes,
So how the court can go into
my lord,
further?
for this reason, my lord, I am submitting, my
court
lord,
cannot
kindly,
extend
and
it
there are
kindly some time may be extended
No,
so
no,
that we
you
can
go
pay,
file
my
the
lord.
application before the DRT
Yes.
and take time.
that is the appropriate relief, my lord. According to the circuit.
I am not denying that. I am not denying that. But ultimately, my lord, that was a loan of 12 lakhs. My
This
lord,
court only can this court only can give some relief to you if you say that by 31st of December you will clear the total amount. Then I will dispose of this application without going into the maintainability.
one minute, my lord.
Without going to the maintainability of question. Otherwise, then you will.
My lord, my instruction is within the month of January, he will pay the entire amount.
I will not.
Cannot happen.
My lord, in course of
Otherwise, my lord, I'll open the arguments with
my
regard
lord,
to the
in course of
maintainability the
tomorrow, my lord, it is very difficult to pay.
Not tomorrow. 30th, I am telling. 30th December.
My lord, he has not
30th
given me the
December,
notices, my lord.
30th
Whatever he is
December.
referring to.
My lord,
these
instead of
notices are
30th
not part of
December,
the
my lord,
writ
only 30 days, my lord, I am praying, my lord.
No.
At least, my lord, the middle of January.
Though the writ petition is not maintainable, I am giving the concession on that. Otherwise, the court is dismissing.
My lord, if my learned senior friend withdraws the writ petition, he will have the liberty to go before the
Correct.
DRT.
That I will
Because once a 13-2 notice has been issued,
Court
it
has-
goes out from the ambit of the writ
now
jurisdiction
you
of
have
the
to face the two hurdle.
Yes.
First is with regard to maintainability
Maintainability.
because the bank is the private bank.
Yes,
One
sir.
thing. Second, now 13-2 has been issued whether this court is having the jurisdiction. These are the two hurdles.
Recent judgments are there, my lord. My lord is aware.
Two hurdles. You are having two hurdles.
My lord, I am very
And third, I will give the option. Either you withdraw, go to the appropriate forum in terms of the law, or you deposit the amount by 30th. I will dispose of.
My lord, I shall deposit, my lord. Kindly extend some more time, my lord. At least 2 weeks more time.
So court is going far away.
My lord,
giving us
at
law.
least 2 weeks more time, my lord. I shall
This
pay.
court find that the petitioner has. So I am dismissing it.
Yes, my lord.
I am dismissing the writ application. Non-maintainable.
As
because
not
it-
maintainable. Yes,
As not maintainable.
Yes.
The petitioner has challenged the present writ application on the ground that the bank has issued the
My
notice.
lord, only liberty, my lord, may be given, my lord. I shall make an representation before the
So
bank.
that's why you withdraw it. I am giving the liberty to take appropriate step before the appropriate forum.
Yes, my lord.
The counsel for the petition prays for withdrawal of the writ application with the liberty to take appropriate step before the appropriate forum. Consider the submission made by the counsel for the petition WPA 10325 of 2025 is dismissed as withdrawn. Liberty to the petitioner to take appropriate steps in accordance with law.
And my lord, only one thing, my lord, kindly liberty may be given to made a representation for settlement of the dues, and that will consider the bank, my lord.
It is also made clear that the petitioner is also liberty to make appropriate representation to the bank for consideration of the case of the petitioner.
Grateful.
Next.
My lord, item number 15, I am praying for not today only, my lord.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear in the combined monthly list of February 2026. Next.
Grateful.
My lord, I appear on behalf of the CSC in this matter.
Yes. Yes, what is the prayer?
On the last occasion, there was a direction to.
Lordship, I was directed to serve upon the added respondent the copy of the report. Lordship, at this stage, what I am praying, Lordship, I will file one exception to this report, Lordship. I could not file my petitioner is out of Kolkata, Lordship.
Well, I would like to file a reply to the exception.
On 5th January,
Petitioner has filed the affidavit service. Let the same be kept with the record. The petition prays for time to file exception to the report filed by the CSC Limited. Let exception be filed within.
Lordship, with 5th January.
Within 1 week after vacation. Police after serving the copy to the land counsel for the CSC.
I would like to file a reply to this.
What reply?
Why I am telling my lord?
CSC is given liberty to file reply, if any, to the exception within a week thereafter. List the matter on 15th of January.
Under the same heading, Lordship. Under the same heading.
Under the same head.
My lord,
My lord, will your lordship will be sitting
Yes.
at 2 p.m.?
Yes.
My lord, kindly hear me for a moment. Yesterday, I mentioned the matter. Your lordship were kind enough to direct the court officer to specially fix the matter in the.
Onsa matter? Which matter?
My lord, that the daughter of the petitioner whose electricity got disconnected.
Which matter? Which matter?
79.
79. Who is appearing for the authority?
My lord, usually Dibanjal appears, my lord.
CSC?
Yes.
yes, but my lord can regularize my
Yes, I will regularize. Give the 1/3 item number.
79, my
79. Give the
79.
79.
Similar prayer, my lord.
79. I am regularizing you.
My lord.
With regard to the student
Will your
education.
lordship be kind enough to take it up at 2 o'clock? I'll take instruction.
Before your lordship rises, Milord, item number 76, Milord, it is that commissioning couple wants to have a baby through IVF, Milord. This, Milord, the female, Milord, the writ petition will become infructuous, Milord.
Seat মানে কখন নেবে?
102, I'll get the other side, my lord. Since the matter, my lord, granted me leave, my lord, to move the matter on an urgent basis.
Well, the singular is my matter, my lord.
Counsel for the commission is there. Can serve notice, my lord.
108.
Well, it's my matter, my lord. In the morning, I mentioned this matter, my lord. My only difficulty is that the notice says, unless I produce the certificate on the day of verification, my lord, my candidature will be cancelled. No, in the some protection, my lord.
I get EWS today. I cannot be EWS after.
Right.
You cannot be EW. As per as my knowledge, since when I am knowing you, you are not the EW.
Well, only 98 and 108 are similar matter, my lord.
Come on, second.
Only one indulgence, my lord. Sir, act second.
See, Mr. Samim, what's the Mr.
Sir, only one indulgence. I believe that this will not prejudice anybody. Let them not, if it is not taken up on by 5th, let them not insist on certificate on the day of verification. You will decides.
See, come on.
This much.
If anything progress has been done, inform this court on 5th. I will fix on 5th. If any progress has been done,
They have given a notice.
Correct.
That it will be.
You inform the authority, come on 5th, I will, because he is not in a position, if I cannot, this court cannot pass any order.
But I believe this will not prejudice anybody, my lord. If they one line order is passed, they will not insist on certificate on 5th. That will suffice. If I cannot produce certificate on the next day, they will cancel my candidature.
Whatever has been done, but it's not done, but nothing has been done.
There is a notice, my lord. I have annexed.
On instruction.
Kindly record that. One line order, my lord. One line.
Item number?
98 and 108.
98 and 108. 98 and 101.
108. Similar matter.
Let both the matter appear on 5th. Let the matter appear on 5th January 2025 as per the
preferably at top, my lord. Preferably at top, my lord.
Something
at top, if possible.
Within 10 minutes.
Grateful, man.
Within 10 minutes, and the heading at urgent notice. Then I am not passing. Not only at John. Let you come on that day. I will record. Yes. Correct. As per the submission made by the consultant respondent.
Economically wealthiest. Why not know? Economically wealthiest. Economically wealthiest.
That's why I told Mr. Banerjee. Since when I am knowing Mr. Banerjee, I don't think he is the EWL. Yes, 76 will order.
Item 102, my lord. It's against the.
What is the urgency?
The urgency, my lord, as I indicated, my lord, this arises out of, my lord, the SIR, Special Intensive Revision, my lord, which is ongoing. I have made a representation, my lord, as a voter to implement a judgment of the Honorable Division Bench passed by the Honorable High Court at Calcutta. OBC certificates in respect of, my lord, 77 categories, my lord, of people belonging to the minority that has been set aside by way of prospective overruling. The Honorable Division Bench says that from the date till the date of judgment, that is 22/5/2024, from 2011, my lord, no effect can be given to the certificate. Now, we find, my lord, that the model adopted in Bihar in respect of SIR has been also made applicable in respect of West Bengal. The enumeration form for West Bengal also, my lord, contains OBC certificate as one of the documents. So, my lord, they should issue a corrigendum that no OBC, save and except, my lord, these classes, my lord, for which it has already been struck down, and, my lord, the order has not been interfered with, not been stayed, my lord, by the Honorable Supreme Court. I have my
which called the authority.
Prayer is very innocuous. My lord, I have made a representation at page 286. Let them decide and, my lord, pass a recent order within 48 hours.
Your Lordship, please, one, the SIR process has been
Started.
The Supreme Court has said not to interfere with the SIR.
Correct. I am not going to pass. Only the representation filed by the petitioner be considered.
Supreme Court is testing the validity of SIR.
Correct. So this court is not only the representation made by the petitioner be considered within how much time it will take?
48 hours, my lord. Let us do it. It's pending since 4th of December.
Where is the give the writ petition? Where is the writ petition?
102, item 102.
You have a copy.
Take my copy. This is the representation. I have handed up the second volume.
Page number?
My lord, 286, my lord. This is volume 2. Volume 2. Regular 2. Page 286. No, ठीक है. No, आ जाएगा.
100 item
102. 102, my lord.
The only grievance of the petitioner in the present writ application that the petitioner has made a representation to the election commissioner from Election Commission of India, as well as the Chief Electoral Officer from West Bengal State Election Commission, requesting to take up the matter at the earliest with all due seriousness and issue suitable guidelines of the circular of the corrigendum as it deemed fit, preferably within 48 hours from receiving the communication, directing the officers of the agent of the men not to accept such invalid OBCs, accept such invalid OBC certificates in the state of West Bengal as a document to claim entry in the upcoming revised electoral roll. Not come across. Counsel for the petition submitted, though the application has been made on 4th of December 2025, but till date no decision has been taken by the authority. Accordingly, the petition has filed the present date application. Learned Counsel appearing for the Union of India.
No, ECI is this whole respondent.
Of India, submit that the matter is pending before the Honorable Supreme Court with regard to the validity of the special intensive revision within bracket SIR of the electoral rolls. Electoral roll, and as such, no order can be passed in the present.
We are not challenging the SIR process.
Application. This court finds that the petitioner has not challenged any procedure of the SIR. The only the petitioner grievance, the petitioner has made a representation to the ECI for consideration of his grievances, but that has not been considered. Considering the above, this court finds that no purpose will be sought by keeping the petition pending. According, the writ petition is disposed of by directing.
Respondent number 5, my lord. Is the Chief Electoral Officer, West Bengal State Election.
The respondent number 5, 2. Respondent number 5, Chief Electoral Officer of West Bengal.
Well, yes, Chief Electoral Officer, Election for West Bengal in Election Commission of India.
West Bengal, to consider the representation submitted by the petition dated 4th of December 2025 and to pass the reason in speaking order and to communicate the same to the petition within a week from the date of receipt of the.
Extremely grateful to your lordship. Extremely grateful. Well, I'll seize the opportunity to extend season's greetings to your lordship and with advanced wishes, my lord, for a very happy new year.
Thank you.
And an assurance, my lord, not coming back in 2025 to trouble your lordship.
Thank you.
My lord,
What is the
yes, my lord, Mr.
where is your writ petition?
79, item number.
Where is your writ petition?
Item number
Item number
79.
79.
Yes, what is the content, sir? What is the who's for the you are appearing for the
It's just been intimated.
My lord,
Lordship knows.
only I am taking as a urgent matter because student examination.
yes, my lord.
Lordship,
My lord,
let him complete.
Yes.
my lord, kindly straightway come to, my lord, page number 23.
Yes.
My lord, in a particular premises, there are 4 meters running, and my lord, I'm not going into the details of the facts for the paucity of time, because what I intend to bring to your lordship's notice the provisional assessment order. Absolutely bad in law, my lord.
In whose name in this 4 meters you are?
My lord, I am
Sarkar.
for Maya Sarkar. Yes, my lord.
Second number.
Second number.
What is
My
that?
lord, my lord, kindly comes to the, my lord, third paragraph. Further, at the time of inspection, it was not possible to measure
estimate at what proportion the individual meter holders, consumer beneficiaries were consuming unauthorized electricity, bypassing the meter arrangement. And my lord, by holding this, they have sent a consolidated amount. My lord, there are other brothers. My lord, we don't know who did this. My lord, if your lordship also sees the photo.
What has happened? Electricity disconnected?
Yes, my lord.
So what? I am.
My lord.
Where is your student certificate?
My lord, my lord, seize, my lord. My lord, her examination is due, my lord. Kindly see her daughter's examination. As we have pleaded your lordship that in the month of January, only till that, my lord, at least it requires to be substantially heard, my lord.
What is which class? BCom.
BCom, my lord. Yes, my lord. Yes.
5.
Yes, my lord.
Semester.
My exam is to
The
be taken
internal examination.
January. 5th January. It will start from 5th January 2026. So, my lord, my only submission before your lordship is that till a substantial period, my lord, let the connection be given for the interim period, and this matter may be heard substantially where there are question of law involved, my lord.
Yes.
This is very unfortunate, lordship. This writ petition has been taken up. If your lordship kindly said, it has been affirmed on 19th November 2025. And very interestingly, the final order of assessment, which is admittedly passed on 28th of August 2025, that has not been annexed in this writ petition. And they have all
we are not given.
They have already admitted. Kindly see paragraph. That is in the paragraph 20, where they have admitted that they have received the final order of assessment for the base. Page 8, page 20. Page 20. But this is a very unfortunate case, and this is a case where the final order of assessment passed on 28/8/2025, and they have taken the writ petition on 19th of May. Lordship knows on the few days back, your lordship has passed the order 120, and it is barred by limitations, and they cannot revive the limitation period. May I hand over that order, lordship? This is the order, and this is the case where there is a direct connection. On the basis of direct connections, their 4 brothers are utilizing this, and on that basis, it has been disconnected. Due procedure of law has been filed. So notice has been sub admitted fact. Photographs has been given, everything has been completed. Now, this is not the court of inquiry where everything can be determined. If they have been agreed, they could have preferred an appeal under section 127, and they have missed the bus. And after that, they are trying to revive the limitation period.
My lord, my case is
when the disconnection was got
on 9/8/2025.
9/8 August 2025, it was disconnected, my lord.
And the final order of assessment has been passed after granting 2 opportunity of hearing.
It is not about the final order.
28/8/2025. Let me complete. And the final order of assessment has been passed, and that has not been annexed.
Where is the final order?
This is the final order. I am.
See whether it is a replica or not, my lord.
It may be replica.
Maybe
replica.
No, that was not in our hand, my lord.
Everything
She
is that
absolutely,
document.
my lord.
But that
very uneducated, my lord.
sympathetical ground, there is no part of the sympathetical ground here.
No,
once you have committed unauthorized of electricity, you are bound to pay the entire
I will be addressing the court on the point of law itself, my lord.
After 30 days, you cannot do anything.
I just want, my lord, if your lordship so desires, my lord, kindly give us a bit time, because the point of law is serious, my lord.
What is the point of law?
My lord, let me tell you.
Once the final order is in passed, assessment order is passed, there is
you
have to go to the appeal.
Very well, my lord. Kindly seize the final order once again, my lord.
I have gone.
My lord, can and consolidated order. Then, my lord, what amount I have to pay? My lord, let him say.
Why you not file the appeal and challenge the order?
My lord, I am submitting your lordship that this petitioner, Maya Sarkar, is absolutely an uneducated lady, my lord.
Okay, you could have.
My lord, I understand. I bow down to your lordship. That is the fault on my part. I bow down. But my lord, also consider what amount I have to pay. 2,050, 2,000, my lord, 2 lakh.
You could have been appealed before the appellate authority. Appellate authority would call the.
My lord,
You know, the August 2000, not December.
My lord, once they have
You filed
stated.
the writ application when?
My lord,
After 30 days, Lordship, kindly.
we have filed the writ application.
But they have November.
November, my lord.
August, the order was passed.
My lord, the puja vacation ensued, my lord. We could.
Interestingly, they never annexed the final order of assessment.
Final order was communicated to us. That is what-
Equity.
My
One
lord,
who seek
thing, my lord.
equity must come in the
My
court
lord,
with a
kindly
clean hand.
consider one thing. How much amount I have to pay?
That will be decided.
They
by the
cannot, my
appeal
lord. They have admitted they cannot. My lord, it is in their order. My lord, only one thing, my lord, only one thing, my lord. Subject to your lordship.
I have taken this matter on
Yes,
the undertaking of the
absolutely.
petition, but this court find that what the submission is made by the learned counsel at the time mentioning the matter, that is not correct.
No, what I am
taking
student.
the petition with the cost and given
My lord,
the liberty to approach.
My lord, I have not submitted anything other than.
You are not there when she has mentioned the matter, and the court has already
stated.
informed. Yes.
She stated her examination.
The assessment. She has not stated the assessment order is passed. She has only stated the illegally disconnection has
Disconnected,
been
my
made.
lord.
Disconnection has been made, and the petition is facing difficulty because
that is right.
Only on the basis of the ground of the student that the matter has been taken.
That is only our ground.
Yes, but where is the ground? The assessment order is there. And that is of 2020, August 2025, and you filed the writ petition in 29 and November 2025.
November 25,
and your
puja vacation was there.
in the month of December 2025.
Puja vacation was there, but it was not taken up. That is why I had to.
The petitioner
My lord,
has
kindly
filed
consider this, my lord.
the present application.
We have not submitted anything wrong before your lordship.
Present application for a direction upon the respondent number 2 for grant of electric connection. Full stop. Counsel for the petition submit that on 9th of August 2025, the authorities have issued the provisional assessment order directing the petitioner for payment of rupees 2,57,362, inclusive of electricity duty as applicable payable to the state government. Full. Counsel for the petition submit that in the said order there are altogether four consumers, but the authorities have calculated the total amount, has concluded the amount of rupees 2,57,362 and has not been segregated how much amount is to be paid by the petitioner. Due to which the petitioner is not in position to pay the amount. Full stop. The counsel for the petitioner further submit that due to the disconnection of the electric connection, the daughter
My lord, daughter, my lord.
the daughter of the petitioner is facing great difficulties as she is the student of BCom, and examination of the 5th semester examination would be commencing from 5th of January 2026, and due to non-availability of the electricity connection, the petitioner is facing difficulties. The daughter of the petitioner is facing difficulty to prepare for our examination without the electricity. Full stop. The learned counsel appearing for the WBSC DCS
CSC Lordship.
Limited submit that after the provisional order dated 9th of August 2025, in the provisional order dated 9th August 2025, it is categorically stated that hearing will be given on 18th of August 2025 at 10 a.m. in the office of the assessing officer. But the petitioner, he has appeared, but the petitioner failed to appear before the assessing officer on 18th August 2025.
Further opportunity given.
Subsequently, again, an opportunity was given to the petitioner, but the petitioner failed to appear before the assessing officer, and accordingly, finding no other alternative, the assessing officer has passed the final order on 26th of August 2025. He further submit that the final order of assessment is an appealable order.
And they have received it, admitted
order, but the petitioner has not filed any appeal against the final order of assessment dated 26th of August 2025. Full stop. He further submit that as per the provisions of section 1.
They have appeared, Lordship. They have appeared.
Appeared.
My lord, that is what I said, my lord.
So appeared. Both that day they appeared.
There are 4 of them. Out of them, 2 of them appeared, Lordship, and 2 of them not appeared.
That is why they asked me to pay the entire amount.
Not appeared. Out of 4 persons, only 2 persons have appeared. 2 persons. Full stop. First, final order of assessment is appealable order, but the petitioner has not preferred any appeal. He further submit that the petitioner has filed the present writ application in the month of November 2025, though the final assessment order is passed on 26th of August 2025, and receipt of the final assessment order is admitted by the petitioner in paragraph 20 of the writ application. Full stop. He further, the learned counsel for the respondent has relied upon the unreported judgment order passed by this court dated 11th of December 2025 in WPA number 2554 of 2025 in the matter of Muhammad Sakil Ahmed versus CSC Limited, and submit that this court has categorically held that if the final order is passed and within the period of limitation, if the petitioner has not prepared an appeal, this court cannot condone the delay. This court cannot condone the delay for preparing an appeal. Full stop. At the learned counsel for the respective parties, this court find that initially the authorities have issued a provisional order of assessment on 9th of August 2025. Thereafter, opportunity and dates were fixed for hearing of the petitioners, but out of the 4 persons, only 2 persons had appeared.
I was there.
Only on 26th of August 2025, the assessing officer has passed the final order. The grievance of the petitioner is that the assessing officer assessed the amount of rupees 2 lakh. What is the total amount?
My amount is
2 lakh.
The final order 2,57,362. But it is not specify which person is entitled to pay, which person is liable to pay how much amount. As the assessing officer assessed the said amount, including the 4 persons, four consumers. Foolish. This court find that if the petitioner is agreed only with regard to the quantum of assessment, the petitioner ought to have approached the appellate authority or by filing a review application before the assessing officer for clarification with regard to how much amount is required to be paid by the petitioner, but the petitioner has not done so. Thus, this court did not find any merit in the present application. The writ petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioner to take appropriate steps before the appropriate authority for clarification how much amount is to be paid by the petitioner.
I'm deeply obliged.
Amount of rupees 69. It is further made clear that if any clarification has been given by the authority, the petitioner paid the said amount, the electric connection shall be restored by the petitioner in accordance with.
I'm deeply
obliged.
Yes. 76.
90.
Yes. What is the urgency? This required hearing, sir.
Require hearing, what happened, the ladies, time is passing, that is the whole difficulty. This is medically, he has been otherwise declared medically fit, but due to the age limit, that is not being permitted. That is the whole difficulty.
Yes.
On the last occasion, I have submitted my instruction, my lord. And the only difficulty is, my lord, the husband is the overaged, my lord, as per the act, my lord. And why this, my lord, kindly look into the last page of my instruction, my lord. This is the reason for prescribing the age limit, my lord.
Yes, that is there in the statute.
Yes, my lord.
You have submitted the report.
Not report, instruction, my lord. Last occasion, my lord.
Instruction.
I am not opposing, my lord, but my lord, this is my instruction. I am just submitting, my lord.
Where is the instruction?
Can you look into the last page? Last occasion I submitted, my lord. This is the part of the act, my lord.
Yes.
Yes, it is there in the act. Kindly see page 19.
19.
Yes, 19.
Yes.
Kindly see, my lord, on the left hand side, my lord, the age is of the husband is given 57 years. Page 19. This is a prescription of Dr. G.V. Dotto. Kindly see 57 years.
Where is?
Handwritten in the husband. Yeah, this is the
Left-hand side.
Left-hand side.
Yes.
Kindly see, Milord, at the bottom, there are 3 lines given, Milord. Kindly see, or age limit does not permit for IVF. So this is, then Milord kindly comes to Milord, the page 60. Page 60. This is the another Milord medical prescription continuation is at page 61. Advice at the
91.
top. Kindly
91.
see, Milord, at the middle, Milord, there is another advice given. The patient is clinically fit as per all reports and examination. No apparent and
Page 60.
Page 61, Milord. 60.
Yes, patient is clinically fit.
And as per all reports and examination, no apparent abnormality committed. Then Milord, opinion regarding IVF should be taken from gynecologist Dr. G.V. Dotto as age is inappropriate. The only thing is age. And the Milord, I visited Dr. G.V. Dotto and he says Milord, that age limit. Therefore, only thing is age limit. I am clinically, Milord, fit, Milord. That is, Milord.
But the problem is that matter is pending before the division.
No, that is not, yes. We have checked up. Milord, the matter, what matter is pending. Here, Milord, what happened? A Bangladeshi couple who wanted to take this facility. Milord,
Not this.
Yes, Milord, this is the one. This is our division bench.
Where is the order?
Milord, no order has been passed. This is the case status pending. Now, Milord, what happened since Milord, if a Bangladeshi Milord if a couple gives birth to India, there is a question of citizenship. That's why the Union of India had preferred an appeal.
No, the division bench of Kerala High Court challenging the order. This division, our High Court. Yes, Kerala High Court I state referring this order also.
We have not filed it.
But problem is, Milord, that
that's why the government of state of West Bengal, the advocates are not coming prepared. Only they are taking the brief, coming, yes, we have no objection. You have no idea. You are not reading the briefs. There is the similar order was passed by the Kerala High Court referring the judgment of our High Court, then went to the division bench. Division bench has stated the total order of the single bench of the Kerala High Court. I could not refer the matter. That judgment is. That's why I am worrying about.
Did not file any appeal, my lord.
They are not, but the Kerala High Court division bench has stated that the referring this order, Justice Sinha's order and Justice Bhattacharya order.
But Justice Sinha's order and Justice Milord order of this High Court cannot be stayed. That may be a concurrent.
That's why they have considered this order and passed the order. But the division bench of Kerala High Court issue is the same.
But this is the.
But you do one thing. I am fixing on 5th within 10 matters. 6 I am fixing.
Yes.
In the meantime, you search it out. You search it out. If it is not there, I will pass approval.
I'm grateful to you.
Correct. Because you search it out, I will take it. If it is not there, and the facts is that, then let us see. Let the court. Let the matter appear on 6th of January 2026 under the heading urgent motion within 10 matters.
Kindly record my instruction is kept in record, my lord.
Instruction submitted by the state advocate be kept with the record. Yes,
I'm
next.
grateful to you, Lord. Let us come back on the.
Next, call the list. Yes, what is the matter?
My lord, this is my affidavit of service.
This matter?
Yes, 91.
Yes.
My lord, this is regarding the 4 tenders in BSNL. I have participated in all the 4 tenders, and there are
4 tenders you filed 1 writ application.
Same nature of job.
Maybe.
Same nature of job. Same nature of job.
4 works, 4 tenders.
At a time.
Maybe.
Same evaluation committee.
Maybe.
Has taken.
Maybe. How the one writ petition?
1 writ petition.
How it can be?
Same job.
Maybe, sir.
Anyway,
Maybe,
my lord.
sir, 4 writ petition, 4 work order. Maybe same officer.
No, that is not
same officer.
That is not the work order stage. My lord, I am briefing.
Bid notice. So how the one writ petition is maintainable here? How? Satisfy this court. One writ petition is maintainable for the work for notice of tender.
For at a time, 4 tenders
Maybe, sir. It is
opened
not in one
by
tender.
the same committee. By the
Maybe.
same committee. The matter is related to the tender system is twofold aspect. One is technical bit, another is financial.
There is a Ford contract.
First.
Ford bid.
Let he's facing the cyclone. Let the cyclone.
There
go.
is
Then I
there
will
is
come.
a 2-bid system that is through GEM portal tender and technical bid system and financial bid system. First technical bid evaluation by a technical evaluation committee, and they recommend whether the techno-commercially the firm is eligible, entitled or not, according to the tender conditions. As per the tender conditions and the checklist of the tender, I have submitted all the documents. At first, my lord, I am kindly have a look at page 41 of the checklist. For all tender, it is same.
Yeah.
And all the documents as referred in that, I have filed. Moreover, there is a policy of the GFR 2017 as per rule 144(11). That is a clause of the tender. And as per the said clause, a firm, if he is border share of the neighbor country, he is to submit a certificate from the requisite authority or undertaking. I am Indian company. I am not sharing any border of the neighbor countries, border sharing countries. And in the GEM portal, there is a system. My lord, kindly have a look at page 108, my lord. Holding paper is there too. Page 108.
Yes.
My lord, there is a system in the GEM portal. Offered product belong to border sharing. Offered product belong to border sharing, beneficial ownership control such.
Where?
My lord, page
108.
Page 108.
Correct.
OEM, the offered products belong to land border sharing, beneficial ownership contract for such countries. Moreover, my contract is entirely service related. I am not supplying any equipment or articles, only the cable maintenance job. If there is any fault, I have to repair the fault. If any parts like joint cable, etc. is required, that will be provided by the BSNL. I am only serving the labor for the maintenance of the rest. As per the fault report generated by the BSNL, that is handed over to me, and immediately within 24 hours, that fault is to be restored for maintaining uninterruption telecom services. There is a provision. If either I have to tick on the online bidding system, yes or no. If yes, then I have to provide the certificate of the requisite certificate from the competent authority. Either I have to give an undertaking. But that provision is not in the checklist, because if I have no, then I have not to.
This page 108 connected with which serial number in page 41? Connected with which serial number of page 41?
41.
Page 41.
41, there are altogether 26 items, 26 conditions.
Yes.
Correct.
Yes.
This 10 is connected with which?
No. This document has not referred in the checklist for submission in the technical bit. Because of that document is required, that should be uploaded through system generated. If I tick yes, then I have to automatically, the screen will come.
That's why, where is that condition? If you want, you tick.
Yes, next page. Next page. If yes, next page 109. Whenever it would be yes, then upload the DPIIT registration of the bidders of the countries.
Where from you are getting?
From the system of the.
Where 109? Where is it? It is mentioned.
Under yes, page 8. If ticked, yes is ticked. Duck point 109. If yes, I have given the example. If yes, then it is required. The certificate of the from the authority concerned. Because I am not land sharing.
That's why I'm telling. Sir.
Actually,
So
my
you-
case, in my case, I have ticked no. I have ticked no. Therefore, the subsequent screen in the portal have not appeared. Because I am not land sharing. But on this ground, illogically, they have rejected my tender.
Where is
But
where is the rejection?
yes, sir. Rejection is page 110. 110, 1111. Referring the 14411 of the GFR.
110.
110.
Yes.
Referring
Not meeting the eligibility criteria, disqualified the bids as per the details indicated in the
my lord.
comment.
My lord.
Certificate undertaking rule 144.11 of the, where is our 144.11 rule?
144 rule I am giving my lord. Which 144 টা কোথায় আছে? 144. My lord, have a look. Para 10, page 103.
Yes.
Actually, in GFR 2017, the rule 47 was there, but the subclause 11 was not there. Subsequently, it has been revised by the Ministry of Finance through circular dated 23rd February 23. Can have a look at page 103. According to that.
103.
103.
Where is that rule? Restriction under one. Then
Requirement, a bidder from a country which share a land border, India will be eligible to bid in any procurement, whether goods or services, like this. I am totally Indian company. I am not land sharing with the border.
Another thing is that, my lord,
let me
they
finish.
are not.
Let me finish. Let me finish. Then whenever your turn, you will say.
yes, then
So that clause is, I have ticked no. Naturally, the no certificate is appeared, did not require. So my tender was arbitrarily rejected. Moreover, I am continuing the work similar job in same way, never raised the question. Now, my lord, they have actually in connivance, a cartel or pool has been formed by a group of bidders. And in connivance with the,
what you are relying upon, the court is not having.
I am giving because they have given fabricated record of a bidder. Vodafone South Limited, the company has been merged with the idea in the year 2018, but they have submitted that document, the firm, fabricated document, and we have contacted with that bidder, and they have told that I have never participated in the tender. Those who have participated, they have fabricated.
What reveals this document?
Reveals these documents. One of the Surjo Roy and Company appeared in the Vodafone South Limited. Vodafone South Limited given certificate in favor of a participator, Kormokar Associates, who have also the participants of the tender. And this tender, he himself did not submit it. His signature has been fabricated. And the tenders who have succeeded through technical bids, they have fabricated it. So entire matter required to be called for, and it is.
I not understand with regard to what you want to see from this this order. What you want to.
I want that now they are going to finalize the tender.
That I understand. You have submitted this document.
This document.
How this document is connected?
This is one of the bidder.
Who?
Kormokar Associates. He is one of the bidder, dummy bidder. The fourth successful bidder.
He is the one of the bidder. Then what has happened to this bidder?
The fabricated document, the Vodafone South Limited is no existence. The Vodafone South Limited company have no existence. It has merged with the idea that I given a certificate of registration with that. my lord,
Idea Cellular to the-
Ministry of
Yes, the
Corporate
Idea
Affairs.
Cell- and Idea Cellular Limited is merged with the Idea Limited. So
But,
what you want to establish from here, sir?
Establish from here that a nexus has been initiated in connivance with the departmental officers by the bidders by forming a pool. The record should be called for, and so long the my tender is accepted, I am qualified. The interim stay order immediately is to be passed. They are going to issue the final order.
Yes.
We have successful and already reverse auction completed. And in connivance, the contract awarded in distribution of the 4 firm each, and the entire record to be called for, and these matters
Where is
require.
the document that the Karmakar Associates has been given as a clean sheet and his tender has been accepted?
No,
Then-
it is a dummy tender because they have submitted. My lord, another submission. This is a conspiracy.
Cause of action, not a club.
Yes, what is the further
This
action?
is a conspiracy. Interim stay is required. Entire record may be called for. In violation of the rule 144(11), my tender has been illegally cancelled. I am not giving my proof, but I have been asked for illegal gratification. This case required to be
If
referred
illegal
to
gratification, they
the
filed the next year.
CBI for detailed investigation of the
In the
corruption.
FCR, my lord.
And
That's a different question of law.
And
they shouting about the
Yes.
And
yes, what for the I have no time.
interim
I
stay
am
order.
sending into the after vacation.
I have
Need the submission.
immediate interim stay in operation of
Okay,
the
that's
final
all.
tender. Just
Yes.
my
Kindly come to I kindly come to the page one
but no copy has been served upon me.
everything's up.
My
That is a
lord,
federal service.
my lord, today
Yes.
he mentioned this matter without giving me notice.
With acknowledgement,
On the last occasion,
with acknowledgement on the day of 12th, we have
called to
served.
the officer of the BSNL. He told me, please appear before the honorable court. And
This is the technique of the BSNL. I know everything, the inner side of the BSNL. Every day to the steps they are doing.
but my submission is that there is a 4 cause of action club up in a one repetition, it
Just
cannot
a
be
minute.
sustainable. And another thing is that in the entire bid document, there is a clause of arbitration. If
arbitration is after finalization of the tender, if there is any dispute, that is irrelevant clause. Irrelevant clause, not applicable at this stage. When in case of execution of the work, if there is any dispute, then arbitration is required.
15, the respondent number 1 has received the notice, sir.
but
Chairman,
please give me
you are appearing for whom?
my we have a ETR.
Huh?
ETR, Eastern Telecom Region, my lord.
Chief General Manager on behalf of.
ETR, my lord. BSNL.
BSNL. So chairman has received the notice on 15th of December.
My lord, in the my submission is that
Just a minute. First you clarify whether you are appearing because 50 as per the affidavit of service.
but I am appearing, my lord.
Yeah.
My lord, kindly provide me copy for addressing the honorable court. My lord, kindly
Give the
provide me
copy.
one copy.
Copy, I provided 4 copies.
My lord, first thing is that before entering into the merit of the case, 2 cause of action. One is, my lord, 4 cause of action
That
in one.
that I will take care
Second,
of it.
second point is that he is not annexing the entire bid document. In the bid document, as per the Indian Telegraph Act, there is a clause of arbitration. If any dispute,
Yes.
if any dispute and differences arises, when a person appeared in the tender document after after going through the entire bid document, he is not annexing the entire bid document. In similar matter was dismissed by the previous bench. No, Rajashekar Mantha judgment. No. If there is a clause of arbitration in the contract agreement, my lord, he is not
Agreement question noted.
he is not enter bid document. In the bid document, there must be a clause of arbitration. A similar matter I have dealt with before the কার ঘরে পড়েছিলাম জানো বাবা এর আগের ম্যাটারটা যেটা শেষ করলাম স্মিতা দাস দে তার আগে যে অর্ডারটা হয়েছিল আরবিট্রেশন পয়েন্টের উপরে
Original দিতে হবে।
মানে similar circumstances when dispute and differences arises
in any manner whatsoever, my lord. It is a clause of arbitration.
What is the work name? What is the name of the work?
Work is the, my lord, is a maintenance activity mainly. Maintenance activity.
Maintenance of the
Page 35, my lord.
OFC.
OFC, optical fiber cable.
Yes.
Optical fiber cable, my lord.
Yes. Next. Next. Anything further?
And another thing is, my lord, today matter is 91, my lord. If requirement for the his urgency then mentioning, no notice has been given, my lord.
Okay.
My lord, when a tender is floated and this tender, this maintenance is for the benefit of the entire Army, Navy, Air Force and entire sake of the, my lord, without any cogent reason, he is praying before this honorable court for that if there is a connivance, if there is any malicious proceeding, they file an FIR before the appropriate authority.
Okay.
My humble submission is that, my lord, kindly register your hand for granting the interim order, my lord.
My lord, if interim order is not given, I will suffer from a very payable
Praying
loss.
for a direction upon the respondents.
This is 4 crore standard, my lord.
Praying for the direction, praying for quashing and setting aside the impugned tech report oblique rejection of the financial bid of the petitioner.
Technical bid, sir. My lord, technical bid of the petitioner. Financial bid, my financial bid has not been opened, considered, rejected.
Set aside the impugned.
And latter document, they are not annexed with the writ petition.
How could I avail?
Of the petitioner. Full stop. The petitioner submits that the respondent authorities have published the e-tender notice with respect of 4 works, issued 4 e-tender notices with respect of 4 works. 4 tender notices for maintenance of optical fiber cable routes. The petitioner being full stop. In the tender document, the respondents have disclosed the checklist containing 26 items. The petitioner being eligible for the said tenders has participated in the said tender. In the said tender. On 29/11/2025, the technical bid of the petitioner was rejected on the ground that certificate dash undertaking under rule 114 within bracket small x small I bracket close of the general finance rule financial rule within bracket GFR 2017 not submitted. Police. The petitioner has drawn the attention of this court to the document wherein, which is appearing at page number 108, annexure P3, wherein it is mentioned that the offered products belongs to land border sharing beneficial ownership oblique controls from such countries, but the petitioner has marked as no, and as such the question of submitting certificate giving an undertaking under rule 144 within bracket XI of the GFR 217 is not required, but the respondent authorities have illegally and arbitrarily rejected the technical bid of the petitioner and not allowed the petitioner technical bid of the petitioner. Full stop. Counsel for the petitioner submit that the petitioners and the respondents have considered the the manipulated document of one Karmakar Associates, which Karmakar Associates on the ground that the said firm is associated with the Vodafone South Limited. Vodafone South Limited.
My lord, in similar circumstances, one judgment, my lord.
Vodafone South Limited. And a certificate has been issued certifying that Messrs. Karmakar Associates is working as contractor in the optical fiber cable construction and have been awarded to execute optical fiber cable construction work at Behrampur. Petitioner submit that the certificate which the respondents have relied upon with regard to the Karmakar Associates are the four documents and only to deprive the legitimate claim of the petitioner. That's all.
My lord, the judgment is 2 pages, my lord. My lord, in the third bar, my lord. My lord, this judgment, the Honorable Justice Raichottobadhyay, my lord, specifically similar circumstances. The arbitration clause.
My lord, per contra, Leonard Advocate appearing for the respondents submit that the petitioner in a single writ application has challenged the cancellation of the technical bid in 4 tender process, and as such the writ petition is not maintainable. The learned counsel for the respondent further submit that as per the tender document, arbitration clause is available where?
My lord, kindly look into this order. My lord, in the scheme, my lord. Page is not available for the petition.
My lord, in this session, I have one submission.
Under the scheme,
my lord, one submission, my lord.
There is a specified condition.
My lord, in the computer, my lord.
There is a specific
scheme. Second page is a scheme, my lord. There is no page for this reason unable to.
My lord, one submission in
Mr. Mukherjee, learned counsel appearing for the respondent has raised objection as
but the petitioner, without invoking the provisions of the arbitration, has filed under the scheme contract. There is a provision of arbitration.
Yes,
but without invoking the provision of arbitration, the petitioner has filed the present date application.
My lord, arbitration clause come only after the agreement, awarding contract, not before.
Had the learned counsel for the respect. This is the two submission.
Yes, ma'am.
Had the learned counsel for the respective parties. Learned counsel for the petitioner submit that the clause of arbitration will come into force only
after awarding the final
when an award has been and the work has been awarded to the petitioner.
And at the time of the execution,
if any dispute is not awarded any work to the petitioner, and as such, the arbitration clause will not be applicable to the petitioner.
My lord.
Had the learned counsel for the respective parties peruse the materials on record. This court finds that the authorities have rejected the technical bid of the petitioner on the ground that the petitioner has failed to file the certificate giving an undertaking, failed to file the certificate under Rule 144 within bracket XI of GFR 2017.
My lord, which has not been also provided in the checklist.
17. But as per the document submitted by the petitioner appearing in page 108 and except P3, the petitioner has categorically mentioned that the petitioner is not the offered product is not belong to the land border sharing beneficial ownership public control from such countries, and as such the said clause is not applicable. Considering the full list, this court also find that in the checklist, the said document is not mentioned. Though there are altogether 26 26 item is mentioned, but on the ground which the respondents have cancelled the technical bit, that said document is not appearing in the checklist of the tender document. Considering the above, this court finds that the petitioner has made out a prima facie case and balance of convenience and inconvenience. And if at this stage the respondents are allowed to continue with the for awarding the tender process, awarding the tender work, awarding the work order, ignoring the claim of the petitioner, the petitioner will be prejudiced. Accordingly,
my submission is that there is a clause of arbitration. If any dispute,
Accordingly, the respondents are restrained from finalizing the tender process till 8th of January 2026 or until further order, whichever is earlier. Police list the matter on 8th of January 2026. 8th of January 2026 under the heading adjourn and urgent motion. Police as regard the point raised by the petitioner with regard to the arbitration clause, this court is of the view till date no contact has been entered between the petitioner and the respondent authorities. That the contract period
they entered into the contract. They appeared before the bid document. So there is a
next.
My lord.
Lord, I do not know what is the instruction from my learned friends, my lord.
Yes, any instruction?
My lord, the instruction, my lord, I could not gather, but my lord, 2 to 3 things, my lord, I will just point out before lordship, my lord. My lord, may kindly comes to page number 58.
58?
Yes. That was the order of Justice Bhattacharya, my lord. Honorable Justice Bhattacharya, which starts this entire thing, my lord. Now, my lord, paragraph number 54.
Yes.
However, nothing in this order shall prevent the respondents from proceeding with any investigation against the petitioner and take consequential. My lord, I may read the entire paragraph, my lord. Accordingly, WPA number 14533 of 2023 is allowed on contest, thereby setting aside the impugned order of suspension dated so and so passed by the respondents against the petitioner. All consequential actions, if any, taken pursuant to the said order stand hereby reversed as well. However, nothing in this order shall prevent the respondents from proceeding with any investigation against the petitioner and take consequential steps independently in accordance with the guidelines. Now, my lord, the procedure is that as the instruction has come before me, the procedure is, my lord, if the suspension gets set aside by this honorable court, my lord, the banning procedure gets stopped. Then, my lord, I will have to again on basis of the pending investigation, if there is any investigation, my lord, I will have to issue a show cause or a suspension, and then we'll have to go for the ban.
Correct.
So, my lord, the investigation was not set aside. The investigation was directed. We were at liberty to continue with the investigation. Now, my lord, we issued a fresh show cause notice. Page 65. Kindly comes to that, my lord. Page 65.
Yes.
My lord, may kindly comes to the last paragraph.
Yes.
The allegations made against your company firm are under investigation, examination by the standing banning committee. You are therefore called upon to show cause to any business dealings, as to why business dealings with your firm, interconnected firm, if any, should not be banned by Bokaro Steel Plant. Your reply in your defense should reach this office within 15 days of receipt this letter, failing which it will be presumed that you have no reply to offer and standing committee will proceed for ex parte decision. Now, my lord, may I place this for your lordship, my lord? Suspension and banning. What happens in suspension, my lord? The suspension temporarily, the party is suspended for business dealings till a banning, a final decision in the banning is taken place. So, my lord, by issuing a suspension notice or a show cause notice, we say that you come up and you place your case that why you should not be banned permanently. And, my lord, we had communicated them that an investigation is going against you.
When this notice was issued?
My lord, 15/6/2020.
Thereafter, what has happened?
My lord, may I say that? My lord, we have communicated them, my lord, that investigation.
Continue, I will hear you.
Yes.
But I find that you are wasting the time of the
Yes.
court, then it will.
And now only one
My lord,
thing,
only-
earlier he was standing,
Please,
he was arguing. Now it's a relay race.
Correct.
One
That's
will
why-
sit
that's
and other
why
will
I-
argue.
My lord, that
This is
also I
High
have
Court.
noted.
It is High
Change
Court.
of the advocate will not change
It
the
is
mind
High
of the
Court.
court unless
What are
it's
you up to?
satisfied from the record. Yes, the court.
He think you
court
argue
is
better
not
than him. He
considered.
cannot argue.
This 15, this is a 2024. You tell
It's
me, that's
unfortunate.
why I asked, you tell me.
Under which orders of the court I have blocked, my lord?
Huh?
Under which orders of the court I have blocked, my lord?
Which order?
I was satisfying that only, my lord.
Show
That,
me.
my lord, may kindly comes to page number 70 directly, my lord.
Correct.
My lord, these are the instances that I was directed to place before your lordship, my lord.
Correct.
Now,
correct.
whatever
I
your
am
lordship,
not
my lord, whatever your lordship
you.
decides, my lord. Now, whatever your lordship
No,
decides.
that like, see, you have to given. That's why I have given opportunity.
Where is the decision?
To come where
That
page
of
70.
investigation.
Page 70, my lord.
Yes.
My lord, only one line, my lord, I will show. My lord, the investigation is continue if not already completed.
Correct.
And my lord, the block has been imposed upon them by the recommendation of the investigation.
Where is that
Number 70,
recommendation?
my
So
lord.
that
My lord, page number 70. Last but one paragraph, my lord.
Till the next date, the mentality kept over investigation.
Will continue if not already completed. The investigation is continuing, the investigation has stopped. The recommendation of the investigation committee was to block.
Then let him show that. Let him show that.
Can you put any burden on the investigation? Investigation is what? Unless and until the investigation is not completed.
My lord, investigation
Pending investigation you can
my
take.
investigation has been completed, my lord.
Yes. So where have you submitted the report?
My lord, may kindly comes to page number 67. We were directed not to submit the report.
Then you will punish
Yes.
me.
Page number 67, my lord, kindly come. Correct. It was the order of the court. The petitioners need not reply to the show cause notice till the next date of hearing.
Correct.
My lord, I am mistaken, my lord.
That's it.
My lord, page number 70, my lord, kindly comes. Record in a sealed cover may also be produced. It is submitted that findings of the investigated agency cannot be handed over to the petitioner at this stage.
Correct.
So we were the findings of the investigation we couldn't hand over, my lord.
Correct.
So that is the reason, my lord.
Whether you can acted upon.
My lord, the investigation is complete, my lord. It is in a sealed cover, my lord.
No. Sealed cover. So how you when you are blocked? Tell me. Okay. Okay. I will go with you. When the investigation is complete, tell me the date of
Let him show the report once.
My lord, that is with regard to that writ petition.
I am asking you one thing. Tell me the date of completion of the investigation. Tell me the date. Tell me the date. And tell me the date when you have blocked.
Yes.
These two dates is different.
Block,
If you continue, you are telling that as per the
my lord, blocked, I can tell, my lord. As soon as the show cause notice was issued, he was blocked.
So that time investigation was not
No,
completed.
it was continuing. That is the reason why I have
Not completed.
No, not completed, my lord.
Then
My lord,
so how you can change the instant?
My lord, pendency of investigation committee can recommend us to block, my lord. That was
They can recommend.
You can recommend.
But this court has stated that you can continue, but not to acted upon.
Yes.
Can you acted upon unless and until the opportunity is not given?
No, my lord, may pass. I was instructed to show this to my lord only, my lord. Nothing else. My lord, may pass this.
I wanted to see your officer who has given the instruction
Yes.
to you.
So vindictive.
This
4
court
rounds.
has given an opportunity to you so that he can he can say yes.
Well, whatever lordship orders.
No, not order. The court is thinking about your officer's mind. What is the attitude of your officer about the court?
Yes, absolutely.
And this court is the last court to allow such practice.
No, my lord, whatever your lordship pleases, my lord.
No, I am telling you, you being the officer of the court, and you are dealing with the authorities. You cannot go on the shoe of the authority. You have to put your own opinion to the authorities. The authorities can rely upon your opinion, but you cannot act on the advice of the authority. Only you can take the documents and all the things from the authority, but you cannot put the burden upon the court of the opinion of the authority. Being the government of advocate.
My lord, I remember I was assisting Justice Pratik Prakash Banerjee as his lordship then was at the bar as the junior standing counsel. He told me one day, when you are appearing for authority, you have a greater duty.
Correct.
No, my
They
lord,
took time, they wasted court's time. Now they are coming and saying the same thing.
my lord, we didn't took time when we communicated your lordship's desire to the authority.
The authority person is not above the court.
Only I
Yes.
given one opportunity.
An
so
opportunity
that
we have communicated
authority-
that now.
authority can realize yes what they
No, my lord,
have
the official
done.
instruction is that, my lord, that whatever lordship pleases can, but these things has to be brought before your lordship. Now, whatever lordship pleases, we are before your lordship, my lord.
You proceed with the matter, complete it. That's why pros and cons. Suppose if I will reject the interim order, suppose I will reject the interim order, and you will allow the other party to continue. This punishment may continue, and tomorrow you open the tender, and given the
But the tender has been opened, my lord.
correct, you will give the work order issued.
No,
my
financial bid not open.
That if you issue the work order,
You
you will issue the work order. Correct. And tomorrow the court find that yes, the act of yours is not in accordance with law and if it is set aside. Who will be prejudiced? Court has the equity. Court has to see the equity. Who will be prejudiced? Tell me. Who will prejudice? And suppose today also, I am not telling to give the work order to him. If today the court will allow you to allow the work order.
allows him to participate, my lord.
No, if allow the work order. And
Division.
tomorrow the writ petition will be dismissed. Who will be prejudiced? You will be prejudiced.
But kindly have a look at this division bench order.
That's why I am telling. Only I am giving a direction for affidavits. You file a short affidavit till that no final the
Finalization of the
cannot be finalized, so that the writ petition can be disposed of on a particular day.
My lord, may then kindly prepones, my lord, my learned friend is appearing on that writ petition also. My lord, may kindly prepones the date of that writ petition also. It is still 5th. It is on 5th
I
February.
appreciate that is on 5th of
That is
February.
right. My
This also fixed on
my lord, may kindly fixes both the my lord.
But I don't think January any date is there.
Because my lord, these
How soon you will file the affidavit?
Lord, as your lordship directs, my lord, within the first week of January, we will file, my lord.
So he has to file the reply.
Or 1 week, my lord.
January का कोई date नहीं है. 12 बजे कोई है कौन सा date में है? I mean, that's why I don't want to harm you. I don't want to
My
harm.
lord, may kindly prepones that date also, my lord. My learned friend is appearing that matter also.
15th January.
কবে কবে হচ্ছে
15th January. But how soon you will file the
My
affidavit?
lord,
Tell me that.
within 1 week after vacation, my lord.
Due to 1 week after vacation. So the 2nd January. So the 9th January. Then he has to file by 16th of January. Then matter is to be fixed on 21st. 21st में है देखो 12 बजे 21st of January.
Yes. Lord, only one request, not to your lordships and to him. If it is not taken up on 21st of February, do not take it up on 22nd. I will not be here, my lord. That's the, yes, if it is done, then done.
See,
For some reason, it may not be done. Next day, I will not be available. He
1
should
hour,
not.
1 hour, 20 minutes.
Because
you
two
will
writ petitions, it will take time, and Lord Mr. Dotto, the Learned Advocate General, was leading me in that matter. So he will also be
it will not
addressing
be
my
done, then it will not be completed.
Then that is the difficulty. I think 5th of February instead of 21st, 5th of February, both the matter can be taken up. Since they are
Because,
going,
my lord, there is a recommendation of, my lord, may kindly considers this. There is a recommendation of the Vigilance Commission, my lord. My lord, may
other
kindly
recommendation will not do. There has to be an order. We have to communicate it to.
my officer has to answer, my lord, everything, my lord. Whatever your lordship pleases.
I think, my lord, 5th 2 p.m. My lord may take up both the matters. So Mr. Dotto will lead me in that matter. So both can be decided on 5th of February 2 p.m. So by the end of the day, we will be finished.
I am praying for a January, my lord. Kindly records my submission.
Instead of 21st January, if it could be on 5th of February, only 10 days in between. If I have no problems if my lord keeps it on 21st of January. I'll not stand in the way.
Where is the last order of the High Court?
Lord, I have handed over the last order. Again, I am giving.
No, that's
In the earlier matter.
no in this matter.
In this
Justice Sarkar order.
Justice Sarkar's order. Justice Sarkar's first order, you also will get not at page 66.
Page 66.
65 is the show cause notice. Third show cause notice. 66 is the order.
My lord, 68 is a contested order, my lord.
Where is the so called notice?
Lord, page
65.
65. 65. Lord, 65 comes after 2 rounds of litigation. Single bench division means the third show cause.
On the 3rd round of litigation, the authority A who has issued this notice. The respondent number.
Lord, this is Sale Bokaro AGM MRD in that
The
matter.
respondent authorities have issued.
Yes,
the
respondent
so-called
authority.
notice to the petitioner on 15th of June 2024.
Yes.
Being agreed with the said notice, the petitioner has filed the writ application before this court, and this court has passed an interim order holding that during the pendency of the investigation, which relates to banning the petitioner, this court passed an interim order
On 9th July.
Interim order on 9th of July 2024, direct holding that the petitioner need not to reply to the so-called notice till the next date of hearing. Again, the matter was taken up for hearing on 24th of July 2024, and the said interim order was extended.
Yes.
Was
extended. Extend holo?
Was extended.
Lord, it is now extended till 5th of February 2026. The last order of your lordships.
Where is the order?
I have handed over the
simultaneously full stop. On 19th of December 2025, the interim order is extended till 5th of February 2026.
The earlier extension are on record, Lord. I have annexed.
Full stop. Now, the full stop. Now the petitioner, now the respondents have
page 76 is the tender.
Have issued a tender. Issued a tender for what is the work order?
Page 78. The nature of work you also will get name of the work
for digging.
Yes.
Evacuation of slag/scrap/musk/debris from slag pits and various bays of SMS, transportation of slag, musk, debris to material recovery plant, and segregation and processing of scrap to chargeable size and transport to magnetic yard of SMS. The petitioner has participated in this tender, but has found that intend to participate in the said tender, but the tender document has not been accepted on the ground that the vendor V100076497 is blocked, which is the number of the petitioner. Which is the number of your petitioner? This V1000 of the petitioner. Petitioner.
Registered number. Registered vendor number. Vendor number. Registered vendor number.
Yep.
Registered vendor number.
Not accepted on the ground of the tender.
Vendor code. Registered vendor. Vendor code.
Registered vendor code number so and so, which is allotted to the petitioner is blocked. Is blocked. Is blocked. वो तो number ऊपर दे दिया ना. Full stop. When the petitioner came to know, the petitioner has made a detailed representation informing the total circumstances of the cases to the respondent authorities on 21st of November 2025. In spite of receipt of the said representation, the authorities have not considered the same and continuing with the process of issuing the work order to third party.
Now, continuing the process of tender, Lord, work order is not.
Continuing the process of tender for issuance of work order. It is not
now, Lord, technical bid has to be evaluated, then financial shall be open. Yes, then work order.
Full stop. This court find that.
Well, may I submit the stage of the tender, my lord? The bid has been opened, 7 persons are participating.
I will come to you. Continuing with the tender process. We further submit that if the respondents are allowed to continue with the tender process without allowing the petitioner to participate in the said tender, and if the petitioner will get, if the repetition filed by the petitioner will allowed, the petitioner will be prejudiced. On per contra, learned counsel for the petitioner submit that a so-called notice has been issued to the petitioner and investigation is also conducted, and this court though has directed the petitioner not to submit the reply to the so-called notice, but Simultaneously, simultaneously, the authorities are allowed to continue the investigation against the petitioner. He further submit that continuation of the investigation against the petitioner, the authorities have blocked the the vendor number of the petitioner, code of the petitioner, vendor code of the petitioner. He further submits that the tender process is continuing, and if at this stage, if this court will pass an order of injunction, authority will suffer irreparable loss and injury. Yes, what is the further submission?
My lord, the technical bit has already been opened.
I have recorded
And my lord, another thing is that, my lord, let me kindly note this. My lord, 2 times extensions were granted by of the tender, my lord. My learned friend has pointed out before your lordship, my lord. They have affirmed the repetition on 19th December itself, my lord, on the day when the tender was about to open.
The further submit that
the original date was on 21st November.
The original date of opening of the last date of the tender, the authorities have extended the last date of tender twice, but in the meantime, the petitioner has not taken any steps. Only when the last date of opening of tender, but only on the last date of opening of tender, the petitioner has filed the present date application. He further submit that the intention of the petition only to install the tender process. Had the learned counsel for the respective parties peruse the materials on record. This court find that the authorities have issued the so-called notice upon the petitioner, and the petitioner has challenged the so-called notice. This court prima facie satisfied. This court passed an interim order directing the petitioner not to reply the so-called notice till the next date of hearing. Accordingly, the said interim order is extended from time to time, but the investigation is continuing. Now the respondent submit that the investigation has been completed. But in terms of the order passed by this court, the investigation report could not be supplied to the petitioner. Considering the above, this court find that this writ petition has to be decided as expeditiously as possible by giving an opportunity of on exchange of affidavits by the parties. Accordingly, the respondents are directed to file affidavit in opposition by 9th of January 2026 after serving the copy to the learned counsel for the petitioner. The petitioner is directed to file reply by 16th of January 2026. List the matter on when you will not available.
Not from 22nd to 27th. Only that.
20 खाली है 12 बजे.
29 कर दो 29.
20. Let the matter appear on 20 and 21st of January 2026 at 12 noon.
My lord, along with that matter, my lord.
20 and 21, both at 12 noon.
My lord, may kindly tax this petition along with that matter so that
12 noon for as a specially fixed matter. Full stop. What is the connected with that writ application?
My lord, that writ application, my lord, they have challenged the show cause, my lord. So, my lord, these show cause they have challenged, my lord. So, my lord, both the writ petitions may be heard together, my lord. That writ petition, my lord.
It is submitted by the so-called notice which the petition has and the writ petition the earlier writ petition filed by the petition is fixed on 5th of. But both the writ application can be hearing can be completed on 2 days.
I don't think
my lord,
so.
But my lord, because my lord, they have challenged the blocking.
Anyway, let it start. Kindly club both the matter. Let it start.
Kindly clubs because they have challenged the blocking in this writ petition and show cause in that.
Submitted by the connected writ application is pending is fixed on 5th of February 2026. Let the said writ application be placed before this court on 20th January 2026 instead of 5th of January 2020.
Along with this matter, my lord, kindly.
But till such time, they should not proceed further with the tendering process.
Full stop. Till this court find that as this court as this court is of the view that writ application is to be heard expeditiously to exchange of affidavit. In the meantime, the respondents are restrained from processing the tender process.
Proceeding further with the tender process.
As restrained from processing the further tender process till 20 1st of January 2026 or until further order, whichever is checked.
As your lordship pleases.
Come with the affidavit.
On 20th, we'll come with both the matters. But I'm extremely grateful. Your Lord, Joseph কিছু দেখছেন।
Well, may I wish your lordship
আমি নাম্বারটা দিয়ে দিচ্ছি অন্য নাম্বারটা।
My lord, may I wish your lordship a very happy winter vacation, my lord. May I wish your lordship a very happy
Thank you, same to you. Yes.
Only one small request before your lordship rises. The item number 85 had been mentioned a number of times by Mr. Jishnu Chaudhary and Mr. Chayan Gupta. Would your lordship be pleased to take it up on the 6th, my lord?
This item number?
85.
Yes, what's the matter?
My lords, I am an MSME company. My lords, without following any of the notifications or the master directions, I have been declared NPA. I have written time and again saying you have to follow the master circular. Nothing doing. They have shifted the burden, declared me NPA one day after sending a letter. Lord, I can satisfy your lordship right here and now, my lord.
Item number 85.
85.
85 can be fixed.
My lord, the
Fixed on 6th.
6th, my lord, with some precedence, it's 85 today, my lord. If it's
6th.
My lord, may I permit to mention, my lord, item number 100 and 101, my lord.
Lordship, one indulgence.
Item number 100 and 101, my lord.